Good morning, everybody, and welcome, a very warm welcome to this online event, for which we have Irwin Mitchell to thank for its arrangement. What it's essentially about is something which ought to matter to all of us, whichever job we have and whichever side of any dispute or litigation we may be on. We know that, unfortunately, there's a huge number of mistakes made in clinical care, and some of them, as we also know, sadly lead to disaster and great suffering. What we are trying to address today is how we may be able better to deal with those situations, both in terms of timing and in the compassion and care that we show. There are many reasons for being concerned about those aspects of clinical mistakes and what they lead to. Not least, of course, is the time, the delays that occur, but also the strains and stresses which are placed inevitably not only on those who suffer from the clinical mistakes, but also, it should not be forgotten, on the healthcare professionals who found themselves, of course, unwillingly and not with any intention, caught up in disputes about mistakes they are alleged to have made. Those strains and stresses are very familiar to me. Some of you may know that I was at the bar and practiced at the bar for over 50 years, and during that time spent most of my career dealing with medical law in all its different aspects. And I saw, particularly in the earlier days, the immense toll that litigation took on the parties on either side. The stress, the anxiety, the utter exhaustion sometimes of dealing with the whole process, which afflicted so many people. What we are trying to address, of course, is really twofold. First of all, we ought to be addressing the number and seriousness of the mistakes that are made. One of the great concerns that I have about that personally is that the government seems to want to address it from the wrong end. What we ought to be most concerned about, obviously, is that the mistakes are being made repeatedly. And secondly, we ought to be very concerned about the human suffering which is imposed on those who are party to these mistakes. And yet it seems to me that the government and those who have the reins of the Treasury seem determined to tackle the problem by either reducing the damages to which the sufferers are entitled, or by reducing the right to sue, in other words, restricting the litigation right of patients, when any sensible observer would say you ought to be addressing the risks that are run and how to obviate them and to reduce, if not minimize, the mistakes. Anyway, the other feature of today will be to hear from those who've been personally involved in this process. The compassion of which I've spoken is, or was particularly in the past, sadly lacking from the dealings we've had as lawyers and healthcare professionals with those who suffered. And that's something which is crucial for us all to understand and to try and improve as we look at the ways in which modern approaches are being applied to this. Being a veteran of so many cases, I, of course, have seen much of the worst side of healthcare. And I don't want anyone to imagine that I forget the immense good and the vast amount of good work that's done in the NHS in particular by people who are understaffed, underpaid in my opinion, whose morale has been often seriously undermined by endless cuts and working condition problems. But just to end on my rant about this, when people are run over in the street by careless drivers, we don't start blaming the pedestrian who got injured, and we don't blame the judges who award the damages or the lawyers who fight for them. We look at the carelessness of the driving, and we look to how to make the drivers better drivers, and we look to how to make the roads safer. That's the approach which I must say I think is the obviously right one. You'll hear today from some excellent and concerned speakers. Some of them, as you will hear, have been inspired by personal tragedy. I know you've got some of the biographies available. Others, lawyers like me and Guy Forster, and of course from those on the NHS and healthcare side, Professor Draycott and Denise Chaffer, who will be talking from that point of view. And finally, and we're very delighted that he's agreed to do it, we'll be hearing from Jeremy Hunt, the a man who was for a long time the health secretary and who has a very important role, as all of you know, in the current ways in which the House of Commons Health and Social Care Select Committee are charged with addressing all these difficulties, costs and problems. So having said that, I'll welcome, if I may, our first speaker after a few housekeeping matters. First of all, thanks for attending. We are delighted with the mix of audience. We have representatives from all fields which could possibly be relevant to this discussion. Thanks to the participants who are giving up their time, and some of them for describing personal tragedies that they've undergone and the problems that assailed them thereafter. We have some housekeeping, thanks also to those who've submitted questions already. And you can submit additional questions throughout the meeting if you use the Q&A function on your screen. And I think we'll probably be answering them at the end rather than as we go along, but do submit them. And when you do, could you please include your name and your email address? So if, as is possible, I'm afraid, we don't have time to address your particular question, we can respond directly after the event. Finally, I think it's finally, no, not quite. We'll be recording this, so those recordings will be sent to you all. So if you miss any or people speak too fast or you want to revisit what was said, you can do that on the recording. At the end of the session, and this is quite important to Owen Mitchell and the organisers, there will be a feedback link posted on your screens and sent to you. Please just take a couple of minutes to give the feedback for the meeting. It will be very important and a great help in planning and arranging future such events. So having said that, our first speaker today is Joanne Hughes. She suffered the loss of a child some time ago and has made it part of her life's work since then to work with others to try and improve and produce a safer system of working to prevent harm and more compassionate dealings with those who suffer after harm has occurred. She co-founded an institution called the Harmed Patients Alliance with James Titcombe, whose name has appeared on your programme, but sadly has been held up and won't be able to join us today. And they've recently together formed the Harmed Patient Pathway with AVMA. And Joanne has a particular interest in what we've come to call restorative practices in healthcare. So with no more ado, Joanne Hughes.
Thanks very much, James. And with that brilliant introduction, I don't need to hang around with this first slide. So can we move on, please, Taze? Thank you. As James mentioned, I co-founded the Harmed Patients Alliance with James Titcombe a year ago now. And our mission is to work collaboratively towards a future where harmed patients and families are respected and cared for, where their needs are understood and met, their suffering is minimised and their recovery is enabled, where preventable second harm is eliminated. And I've been asked to talk about what matters to families, and I think the essence of what matters to families is reflected there in that mission statement. And Harmed Patients Alliance advocate for restorative healing after healthcare harm. Next slide, please. So what is a restorative approach? It's an approach to harm that seeks to address both the causes and the consequences of the harm in ways that promote accountability, healing, and justice. Next slide, please. So the people affected come together in a safe and controlled environment to share their feelings and opinions truthfully and to resolve together how best to deal with the aftermath. And it's called restorative because it's concerned insofar as possible with the dignity and the well-being of those harmed. So in healthcare, we have a unique situation because the harm has almost never been caused intentionally, and almost never does responsibility fall merely with the person who was providing the care at the moment the event happened. So there are many individuals who need to be curious about and give a truthful account of their role in the harm and to fulfil their obligations now that it has happened. And many of those, though, will be harmed themselves from the knowledge of what's happened. So in healthcare, we need processes that ensure the dignity and well-being of everyone. Next slide, please. And processes can be considered restorative only in so much as they give expression to restorative values: respect, honesty, humility, mutual care, accountability, trust. Of note, these are values that are essential to healthy and just relationships. So the values determine the process, and it's the process that makes visible the values. So as long as the values are honoured, there's room for diversity of processes and a flexibility of practice. And so what I'm going to be talking about today is how we can honour those values in healthcare litigation. Next slide, please. So this is an overview of the core values in restorative processes, and I'm just going to have a brief look at each of them. Next slide, please. So starting with respect. So in restorative approaches, all human beings have inherent and equal worth, irrespective of their actions, and also irrespective of race, culture, gender, orientation, age, beliefs, or status in society. So everyone's spoken to and treated with respect in restorative processes, and also mutual respect engenders trust and good faith between all the people. Next slide, please. Participation is a value. Those most affected, so in our case, patients, families and frontline healthcare providers, really ought to be the main speakers and decision makers in any process, rather than trained professionals representing interests. And all those present in a restorative process have something valuable to contribute to the goals of the process. Next. Honesty. So telling the truth is essential in restorative process if there is to be any justice at all. So in restorative, truth is more than clarifying facts and establishing liability within strict legal parameters. It requires people to speak openly and honestly about their experience of the harm that was caused, their feelings about what has happened, and their moral responsibilities now that it has happened. Next slide. Humility. Restorative approaches accept all human beings are fallible and vulnerable. So we have the humility to recognise this universal human condition, and that enables those with a role in creating the harm and those who are harmed to discover that they probably have more in common as flawed and frail human beings than what divides them as harmed and harmer. And empathy and mutual care and respect are manifestations of this humility. Next slide, please. Interconnectedness. So with a restorative approach, we recognise that there are bonds that connect the people affected. So the people involved in creating the harm and those who are harmed are all valued, and it is recognised that all the people are interconnected by this web of relationships, and the community around them too. So in our case, healthcare, regulators, and even the litigation system, they all share responsibility for these people. They share responsibility for the community members and for the existence of harm. So there's a shared responsibility to help restore those harmed and to promote the learning for change. And those who had a role in creating the harm and those who were harmed are also uniquely bonded together by their event. And often they ultimately are the ones who hold the key to each other's recovery. Next slide, please. Accountability. So when a person's actions have harmed another, that person has a moral obligation to be open about what they know about what happened and be curious to understand more, to be willing to be made aware that something they have done may have contributed to a harmful event, and to be willing to see the impacts of that, to be willing to accept that if they had a role in creating the harm and the impacts of it, they now have a role in mitigating its impacts. So in healthcare, I think this is the accountability that we expect. We expect this of all healthcare staff, And there's a huge focus on trying to create the right conditions in just cultures or restorative just cultures so that staff can enact their moral obligations without fear of unfair blame or punishment. And in restorative approaches, those involved in creating the harm have an opportunity to express genuine remorse for what has happened and for the impact of what has happened, and to make reparation for the impact. And the definition of reparation is to make amends for a wrong that has been done via payment or other assistance to those who have been wronged. It's the action of repairing something. So while forgiveness is not forced or expected, fulfilling moral obligation of accountability in this way in restorative processes opens up the possibility of forgiveness. This response from a harmer can pave the way for reconciliation, and we can see the opportunity for healing of moral injuries this form of accountability provides, and also the way further moral injury is created for all the people when people can't behave in this way. So in a restorative approach, repairing the harm, restoring trust and relationships is really important. We prioritise the well-being of the people by being accountable in this way. Next slide, please. Empowerment. So all human beings require a degree of self-determination and autonomy in their lives. An incident of healthcare harm robs those affected of this. Patients and families have had something happen to them without their consent. So restorative processes are seeking to re-empower and to give them an active role in determining what their needs are now and how those should be met. So in essence, we're seeking to widen that black area in the middle for people. And for clinical staff, we should be aware that this empowerment is twofold, because we recognise that they did not intend the harm. And so the incident has caused them some suffering too. So we need them to be empowered to be able to have their own needs met, as well as empower them to enact their moral obligations to meet the needs of those that were harmed. Next slide, please. And hope. So no matter how bad the impacts of the incident, it may always be possible for the response to lend strength to all those who are suffering and promote healing and change. And because it seeks not just to understand what has happened, but to actually address the needs that have arisen from it, restorative practice nurtures this hope for healing, for learning and change, and for greater safety and civility for everyone going forward. Next slide, please. So I've talked about the values. So the principles of restorative practice, just to run through those quickly. A restoration. So the aim is to address the harm, restore trust and repair relationships. I can't keep repeating that enough. Voluntarism. So taking part is voluntary. It's not forced and it's based on informed choice. Neutrality. So the processes are fair and unbiased towards any particular party. And I would say that it's important that it's multi-partial, that it has equal concern actually for all of the participants. Safety. So we use processes and practices that aim to ensure the safety and well-being of all the people that are within it, both in terms of what we do, our procedures, and the outcomes that we achieve, and to create a space within which people feel very safe to express their feelings and views about the harm that's been caused. We make it accessible to all. It should be non-discriminatory and available to all affected by harm. And of course, we show respect. And I've popped up there just the principles of trauma-informed care, because I think it's important that we remain very conscious that most harm patients and families will have been traumatised. Some people have suffered extreme trauma. And the principles there fit really well with the principles and values of restorative practice. So if we seek to act in this way, we're also going to be in a situation where we're not triggering and further traumatising people that are already suffering. Next slide, please. So on the sort of subject of values and principles, I had a look at NHS Resolution's website. And their definition of resolution is to resolve concerns and disputes fairly. That's what they want to do. They talk about values of professionalism, expertise, being ethical and respectful. So it all ties in with this restorative approach. And what they say is they're genuinely committed to public service and doing the right thing for patients and the NHS and making sure that people have what they need. So again, really very reflective and sits very nicely with what we're advocating with a restorative approach. And I just want to pick up on what they've put here about we resolve concerns and disputes fairly, and have a little think about what that looks like as well. Next slide, please. So I've had a look at some websites concerned with talking about justice and fairness. And justice in its broader sense is action in accordance with the requirements of some law. But in its narrower sense, it's fairness. So it's action that pays regard to people's actual interests and their safety. It's concerned about people's interests and safety. Context is very, very important in fairness. And people want to be treated fairly within fair rules. So fair play is important too. And so I think this is really important because in my humble opinion, there has been lots of further avoidable harm caused to patients and families, and probably indeed staff too, because the approach to healthcare litigation has sat far too much to the left of this picture and not on the right hand side. In healthcare litigation, people have been harmed and genuine needs have emerged. And we need to enable the easing of the suffering of the people. So we do need to have the concern for the safety. We do need to restore their well-being if we can. Context is important. We need to support healing, and we need to operate in a way that supports the just and learning culture the NHS is working so hard to create for the good of everyone. The context is hugely important here, and it must, I believe, influence the approach taken, because while this is just a civil, it is a civil litigation process like any other, the context and the emotions and the harm and the needs created in healthcare litigation is really, really important. The NHS wants a restorative just culture for all the right reasons. So the healthcare litigation industry, for me, needs to be aligned with that. So the goal in healthcare litigation surely has to be to meet people's needs, look at their interests and needs, ensure the safety of these people and their well-being, but also have a role to play in the safety of future patients as well. So healthcare litigation, for me, has to support and complement duty of candour and restorative just culture work that's going on in the NHS. Next slide, please. So just some principles of justice and fairness. The rules are fair to all parties play by the rules. Those words again, respect, dignity, trust, people's well-being is important. And we have a principle of need where everyone gets what they need. We ensure procedures are unbiased, consistent, and generate reliable stuff. And people's judgments of procedural fairness will result from perceptions that throughout the process they've been treated honestly, openly, and with consideration. And of course, that feeds back into dignity, respect, well-being, etc. Thank you. Can you move to the next slide, please? So I've said a lot there. I realised that there's a lot to take on. But the summary is that patients and families, I think, want to be treated in litigation according to restorative values and principles. They want the process to be conscious of their needs as a victim of trauma. They want it to be fair and reliable process. And they want it to uphold dignity, well-being, trust and relationships. Those things are important. And they want the behaviours within litigation to reflect the values that the NHS holds dear. Next slide, please. So in restorative approaches, these are the questions that we're asking. Who's hurt? What do they need? Who had or has a role in the harm that's happened? And who had or has a role in the repair? What obligations do they have? How do we restore trust and repair relationships, and how do we stop this happening again? And so again, I wonder if the litigation side of things needs to pay due regard to these questions, and not merely focus on what happened and does it constitute negligence and can we prove causation. Next slide, please. So I've talked about meeting the needs of the people, and I just wanted to reflect briefly on what might be the needs of the people who the incident actually belongs to, which will be the staff involved and the patients and families. And I really wanted to show that on both sides, I think genuinely, they're very, very, very similar. I think both staff and patients and families just want to really understand properly what exactly has happened here. I think they want to understand their own role, but in context. So staff need that context to be fully considered, and that's part of a just culture. But equally, patients and families too need to work through what happened and their role in it in context, because there can be a hell of a lot of self-blame and guilt around why didn't I do more, and a process that helps them establish all of that for themselves can help them heal too. I think often both want an opportunity for a role in the learning and creating change to prevent a repeat. People want to be able to act with authenticity and integrity. If not, they become morally injured. They want opportunities for moral repair. So for staff, I think for many, they do want to show remorse, apologise and be able to commit to action to prevent a repeat. I think for many patients and families, they want to perceive remorse and receive genuine apology. And when they do, often they have a choice that they actually want to give empathy to the people who created the harm, and they also want to commit to an action to prevent a repeat. I think everyone wants to be treated fairly in a sort of human factors just culture situation where attention is paid to context. I think staff feel better if they know that their patients and families will receive fair compensation. And also everybody wants support for coping and healing. Next slide, please. And in a restorative framework, what we pull out is that people's needs fall into substantive, procedural and psychological categories. And I just want to try and assist your understanding with this, because I think it's really important for the work that's being done in litigation. So for example, if we took compensation, which is a substantive need, patients and families have procedural and psychological needs that are attached to that. So procedurally, how the process of going about achieving compensation is important to them. Their choice and empowerment in the design of that and the implementation, you know, who, what, how, when, where, fair, reliable processes, etc. So that's important to them, and it ties into what I was speaking about earlier. And it's important to their well-being that the procedural needs are met, not just the substantive one, if that makes sense. And equally psychologically, people need to get the feeling that they wanted to feel with the remedy. So you know, things tied up with compensation. I'll talk to my own experience in a minute, but if you're not meeting the feeling that people wanted from the compensation and the meaning and the things that sat around it, it can actually be more damaging than helpful to them. Next slide, please. So with those things in mind, I wanted to use a little bit of my own experience to illustrate things. Bear with me, I'm just making sure that my timer's come up in front of me so I don't run too far over. So I wanted to share this part of my experience with you. So this is in essence what happened with the litigation process for me in terms of getting hold of expert opinions on what had happened to my daughter. So the backstory to this is that for various reasons there hadn't, in my opinion, been sufficient SI investigation. It hadn't been thorough, it hadn't looked at the right things, etc. And I was now in a litigation process whereby On the top, my lawyers had asked some experts to look at all the documents that were available in relation to what had happened, and to review all time periods and find what they found. I don't know what's gone on with my formatting here, but the result of that was that they found that there had been some significant breaches, and they believed there was causation. And these were related in particular to a specific time point reflected in a document that we'll call D, and some later notes. But crucially, all of those documents had been available to them to review. And on the bottom, what I now know happened was that with the expert opinion that was obtained by the trusts, selective documents were supplied to that expert, and they were only asked to look at selected time periods and answer specific questions. And the report that was generated was one where they did not identify the breach and causation, but they could never have, given the information that was fed in. They were not given the relevant record to review, nor asked to look at the relevant time point. But I didn't know what was in the triangles at that point in time. But the experience that I had was that when I received the report and the explanation in the top circle, I felt finally I had a thorough explanation for what had happened to Jasmine. Somebody had looked at it properly, considered everything I wanted them to consider, and given an opinion that seemed to make sense based on the experience that I had, what I'd seen, and things that had happened over time. And I felt a sense of relief when I read that finally I could start making sense of what happened. But that was taken away from me again once that opposing view was put on the table from the other side. And of course I was confused because I'm left now still without an explanation that everybody's on board with as to what happened. We haven't really established what the narrative of events were. And it was important to me to explore these differences of opinion, to see if anything could be resolved, if we could get closer to one explanation, because I needed that one explanation. I wanted to understand what had happened, whatever that was. And I was actually happy for both opinions to be fully tested and explored, to get that explanation and understanding. So it wasn't that I wanted to be a winner, you know, I just needed some exploration and to get closer to what could really be a reliable explanation, if that was possible. And obviously, you know, I wanted a shared understanding of what had happened, because ultimately, if we didn't have that, how could any of the needs that were created from what had happened that I spoke about in the previous slide, for me or the staff or the trust, actually have any hope of being met? So I wanted exploration. But what actually happened in my case is I was told by my own solicitors that the exploration of that nature, having the experts come together in a conference, if you like, is only really on offer once formal proceedings are initiated. And I couldn't initiate formal proceedings without agreeing to try to mediate a settlement first. That would be seen as unreasonable by the court, and it would put me at great financial risk. So my own solicitor was not acting in ways that were concerned with meeting my needs, or trying to meet them, and hadn't really considered that they were part of their own remit or a possibility, I think. And what resulted was a mediated settlement negotiation. So we came with our respective positions, which were what's in those two circles. And what was offered in the mediation was a reasonable settlement amount. And I was forced to accept that, because if I didn't, I would be obviously subject to huge financial risk if I went on to try to initiate formal proceedings to better understand and get a better explanation of what had happened. Next slide, please. So in that situation, I would be considered to have won. I was given a healthy settlement and my costs were paid. But I want you to think about what need was actually met. So these are the questions really with why patients and families come to you wanting compensation to maybe consider. So what does the compensation give the patient or family? Does it hold meaning, or does it have a purpose, or both? What does it symbolise? What does it acknowledge for them? Is it of itself of any value, or is it only of value if it's an integral part of something bigger? And could it actually create harm if given in a vacuum, in the way it was for me? So for me, compensation held the meaning, much more meaning than it did purpose. And that was why I wanted it for the meaning. So for me, it symbolised that Jasmine's life and the quality of my life actually matter. And it provided some dignity to her and also to me. It was validation of my experience and the impacts of that. It was acknowledgement of accountability and the accountability that I was describing earlier. And it was a necessary and component part for me of a meaningful apology. It was a demonstration of the trust's desire to apologise and to try to make amends for the impacts on Jasmine and also the impacts on myself and my husband. So a mere financial transaction held no value to me if it wasn't being given as an integral part of these things that had really mattered. And in fact, it was handed over in a vacuum, and as a result of a process that had sought to invalidate my experience and deny the impacts and avoid accountability. So where the decision to settle was influenced by perceived financial risks, not care or concern for all the things that matter to me. And the decision was potentially limiting the identification of events that could cause harm to other children in the future. So for me, the actions made a mockery of the values held dear by the NHS Resolution and indeed a civil society concerned with the well-being of its citizens. It caused me harm. I was caused harm also because of the attitude of my own solicitors, because it wasn't their job or the job of the court to satisfy my needs. It was simply to secure a financial award which was on offer. And I was also caused harm because I had no choice. I wasn't empowered. I couldn't to accept the settlement at that stage. It was to accept enormous further harm to myself, to Jasmine's dignity and to the safety of future patients. But I had no power to protect myself from that. So it was an incredibly traumatic experience. Next slide, please. I am going to go 5 minutes over. And this was really how that left me feeling. Next slide, please. So thinking about what we were talking about earlier with justice and fairness, I think that my experience can be said to reflect the left-hand side rather than the context, the interests and safety on the right-hand side. And that's why that slide earlier was so important. Next slide, please. So what I experienced was a system in which the players sat too far on the left, and a system with restorative values more aligned with the values of the NHS would have sat more to the right. And I believe we have an opportunity to create a restorative, just, fair system. And I don't think we need a change in any law to create it. I just think we need a change of mindset and a commitment to the well-being and the needs of the people that we're trying to serve. So we need everyone working in and using healthcare litigation to be sitting more on the right of that previous slide. So for me, we've got a real opportunity with mediation. So mediation is the preferred route now to resolving disputes and is recommended to be used wherever possible. So mediation processes that reflect restorative values and principles, where the mediators and the parties' advocates hold restorative values and principles dear, are offering us a huge opportunity to meet everyone's needs for both learning and healing in the aftermath of harm fairly and without causing anyone any more distress. But for me, there are some takeaway messages about what we need mediations to be for and the timing of what we're trying to achieve within them. So I think everyone must truly uphold the values for mediations to be truly restorative. And I think if we do that, essentially what we'd be looking at is mediations that are in 2 parts. So first, you look at and deal with everything accept the value of the settlement. So in restorative mediations, your aim would be to genuinely give people what they need for learning and healing, looking at opportunities for restoration of trust where this is broken and repairing the relationship, learning for safety improvement and the well-being of all people, so doing the right thing. And a mediator's role is to help identify the interests and needs of the parties and how they may align. It's also to ensure the genuine commitment to this and good faith of the parties, so doing some risk analysis first, ensuring the right people are in the room to have these discussions and achieve these solutions that could meet the needs and uphold the values. And the advocate's role is very similar. And for the party's role, it's to behave in ways that uphold restorative values too. And I think that if we can do some of these to meet the needs first, only at the end of these processes where parties do have choice and empowerment to resolve their concerns and have their needs met, drive up empathy and understanding of each other, only then do you move to the second process, which may be a mediated settlement agreement. And I think to do it the other way round runs the risk of we're only really doing these things once financial risk is out of the way. And I wonder how neatly that fits with genuinely being cared with well-being and meeting people's needs fairly. So my final slide, please. So I'm really hopeful that my message has been clear. I think the healthcare litigation industry and all those using it need to be getting much more context specific, to have concern for the dignity and well-being of everyone affected, to enable those moral obligations to be fulfilled, the needs to be met, and to promote learning and healing. It needs to be committed to achieving what's on the right here and making sure what's on the left, an outcome I and many others have experienced, even when we've technically won, is a thing of the past. Let restorative values and principles steer the ship as much as possible. Thanks very much.
Thank you so much, Joanne. I felt that was a most vital message you gave us, and a very important one indeed. It contrasts so much, in particular with my experience in my early days of practice in medical law. The defences in those days didn't have to produce any expert reports on exchange. They didn't have to plead specifically to allegations of negligence. The rules allowed them simply to say negligence is denied. Defences that were of the utterly indefensible were frequently pursued right to the door of the court in the hope that the poor suffering patients would give up in exhaustion and despair. There was a general distaste for the idea of suing the medical profession at all, and the process was extremely damaging to those who had suffered, and in my view, damaging also to the healthcare professionals. We've come a long way since. Things have changed, but we all have a role to play. We all have a part to play in making everything much better than it has been. And I'm so glad when I learned that our audience includes, of course, lawyers, healthcare professionals, risk managers, in-house ones, mediators, legal aid officials and people who work for the legal aid, people from the NHSR, and charities. So we've all heard your message, Joanne, and we're extremely grateful for it. Lessons that you have described. Could I move then to our next speaker, Guy Forster, who's greatly responsible with his colleagues for setting up this event. He's a partner and head of clinical negligence at the Cambridge office of Irwin Mitchell, and has specialised in clinical negligence and in work in personal injury cases of the most serious kind for a long time. He also represents families at inquests, and not just as a lawyer, but it's quite clear that he is one of those who's been working towards a more compassionate view of those injured in these incidents. And also, I'm sure that I do, which is that we have always to remember that the healthcare professionals, although there are occasional bad ones, I know, who don't care, but mostly they suffer as well in mistakes that should not have been made and have led to harm. So I introduce Guy from Irwin Mitchell, and with him, Jasmine Armstrong. She's manager of the Birmingham healthcare team. She's been providing advice on clinical negligence to the NHSR for some time. She gives general healthcare advice. She deals with inquests, breast children, and the CQ and dolls, deprivation of liberty issues, and so on. She trains her colleagues and clients in aspects of healthcare, and she has a very experience in trying to bring innovative methods of dealing with dispute resolution. And I've no doubt you will agree with me that she's an excellent person now to speak from that point. Thank you, both of you, Guy and Jasmine.
Thanks, James. Good morning, everyone. First of all, thanks, Joe, for that brilliant insight. It's always so difficult to hear that your experiences through litigation. We've discussed it many times, but I know that those listening, me included, will have found that incredibly valuable and something I'm sure that we can all take into our daily practice, whatever role that is. In the spirit of collaboration, Jasmine and I are going to speak together to give the lawyer's perspective. We recognise that there'll be a range of views and you might not agree with everything we have to say, so we're really keen for attendees to add their questions and comments along the way, so that hopefully we can open it up for discussion. We might have some time at the end of our slot, but if not, we'll pick it up in the Q&A session this afternoon. As we all know, the world of medical negligence litigation is never really very far away from the spotlight. James has already alluded to the fact that we've come under scrutiny from the Health and Social Care Select Committee, who first of all earlier in the year looked at the safety of maternity services, and now they've opened up an inquiry into NHS litigation reform. Fundamentally, litigation has, I believe, a valuable and necessary role to play in resolving these kind of disputes. It's a sophisticated system that's evolved through decades and decades of careful scrutiny from the judiciary and through Parliament. And it's one that's not only designed to achieve redress for harmed patients, but also there to protect clinicians and healthcare providers too, whilst of course also having the potential to shine light on areas of concern in terms of patient safety. The law of tort on which it's based remains the framework which governs how individuals interact within our society, with a view to preventing harm and providing remedies where harm occurs. And this, of course, applies, as James has alluded to, in countless other areas of daily life, on our roads, in our workplaces, so not just healthcare. The damages we recover for our clients can often be absolutely vital to fund private care, therapies, replace lost income to help pay the bills and simply put food on the table. And whilst it can provide a means to other really important remedies, such as apologies and explanations as part of the process, as we've heard from Joe, that's by no means guaranteed. But when it does achieve those outcomes, they can be just as important to the people that we represent. Like any system, it's not immune from criticism. People will say it takes too long, it's expensive, it doesn't do enough to prevent future harm or to promote patient safety. So it is important to recognise that there are some improvements that could be made in respect of the efficiency of the process, of course the costs involved, and its contribution to improving patient safety. But in order to make those improvements, we really need to have a better understanding of the underlying causes of those issues, which can't necessarily be attributed to any one particular party involved in litigation. And because those aren't well understood, the response can sometimes be to question the system as a whole and to look for alternatives rather than just simply working on improving the existing process, which is still fundamentally fit for purpose. And in my view, the way that we all work together in this space really provides the key to tackling these kinds of challenges. In fact, the NHS Resolution in its recent annual report made a particular point of attributing the reduction of legal costs to a greater cooperation between the parties. For specialist lawyers like us, there really is great value in having good working relationships with counterparts. I was reminded recently by a school friend's post on LinkedIn that how we operate as lawyers in the world of litigation really is quite heavily influenced by our own attitudes and our mindset. He's a partner at a commercial litigation law firm, and he was celebrating the fact that his firm had been named as one of the so-called fearsome foursome in litigation by a particular consulting group. Theirs was one of 4 law firms that clients fear the most in litigation. And to my mind, you know, that might attract kudos in the world of corporate litigation, but in the sphere of medical negligence, which involves so much human emotion and so much personal impact, it is the kind of narrative that we'll be moving away from for some time. Sure, it's important that practitioners are respected for their expertise that they bring along, and certainly they will often be required to take a robust approach in the best interest of their clients. There's no getting away from that. But this undertone of aggression and adversarial litigation isn't usually very helpful in an area of work where there is so much human cost and where emotions run high. So, to my mind, that goes for all of us. It's not just the lawyers on each side; it's our clients too. It's the patients involved. It's their family, but of course, trust representatives and the clinicians involved too. The civil litigation process is just that. It's a process. It's defined by rules we all have to abide by, moving in the direction of a trial in court before a judge, but most likely for us with the prospect of settlement out of court, because something like only 1% end up at trial. It's complex because at the start of that process, often there is a very difficult relationship between patient and healthcare provider. And as we've just heard, the problem is that families often feel like the health profession has closed ranks on them, and then they might turn then to the lawyers to provide a solution. And the cases, by the same token, often, they will involve allegations of professional negligence, and so clinicians might fear reputational harm or action from their regulator or employer, that their clinical practice or their professional pride, in fact, is under attack. So the first thing to look at is how the healthcare system responds to patient safety incidents in the first place. For me, this is the absolute key. How they're investigated, how the patient is engaged, the use of external analysis to identify what went wrong, identifying lessons and embedding change if that's what's needed. As James said at the top, he said that, you know, that there is this still frustrating focus on reducing the value of damages for the harmed patient, and yes, their legal costs too, rather than cutting out the problem at source by preventing harm in the first place. And better responses to a patient safety instance would not only ensure that learning is fed back into the system, but also that clients and their families are given the explanations and assurances that they need at an earlier stage, that their needs that Joe talks about are being met. Now, when something goes wrong, there can be an utterly bewildering array of processes going on. There can be a complaint process, a serious incident investigation, the involvement of HSIB perhaps, a coroner's inquest, GMC, NMC, CQC, a clinical negligence claim, the list goes on. And it's no wonder that the very people who are most affected, our clients and the families on one hand and the clinicians on the other, that they can feel a loss of control. And the process is one that's happening to them rather than them being properly engaged within it. So when lawyers do become involved, I think we're almost uniquely placed to try to unravel that difficult dynamic between the patient and healthcare provider and help provide a more collaborative approach. So what are the barriers to better collaboration and what more can we do? Well, Jasmine's going to elaborate on that shortly, but for my part, collaboration works best when there's a genuine understanding of what everyone is looking to achieve. And one of the most important questions a claimant lawyer will ask of their client at the outset is in fact what they want to achieve. The process of bringing a claim has a specific aim, which is to recover damages for the harm caused by negligence, but all specialist lawyers know that generally that isn't the client's starting point at all. In fact, typically they want answers as to why things went wrong. They might want to hold someone or something accountable for that, and they want reassurances that lessons have been learnt. And yes, usually when there's been serious long-term harm, it would be really important for a client to secure their financial future. Let's remind ourselves for a second that actually the pre-action protocol for the resolution of clinical disputes that we all abide by as lawyers actually requires parties to actively consider whether negotiation or some other form of alternative dispute resolution might enable them to resolve their dispute without starting court proceedings at all. The protocol talks about discussion and negotiation, mediation through a third party, but also arbitration where a third party decides the dispute, or early neutral evaluation where a third party gives an informed opinion on the dispute and recommends an outcome. In reality, how many of our disputes are resolved through arbitration or neutral evaluation? Probably very few indeed. And there has been a rise in the number of mediations in recent years, but still, how many of those are still occurring once court proceedings have been issued rather than beforehand? So why is that? Clearly, for there to be effective resolution at an early stage, each party still needs to feel that they're in a position to have that meaningful dialogue. I don't just mean lawyers, I mean the clients they represent, of course. And it's important they don't feel disadvantaged by the lack of information before them. One advantage of court proceedings is that it gives us rules to provide for that exchange of information. But doing that on a voluntary basis requires trust in the process and engagement in the parties in good faith. In recent years, we can see that trust building, which is enabling that change in culture. But in truth, we're still working on it. In order to see that change, we need as a profession to role model those behaviours to the next generation of lawyers. I feel strongly about that. Essentially, so that we're leaving court to resolve those issues where truly no consensus or compromise can be reached. I mean, that's what they're there for ultimately. Traditionally, ADR has been seen as an add-on to the court process, often deep into litigation. And typically, it's usually meant one thing, and that was lawyer-to-lawyer meetings. I'm not too ashamed to say that a few eyebrows were raised when the NHSR started suggesting mediations with third-party mediators for some cases instead of those traditional lawyer-to-lawyer roundtable settlement meetings. And at the time, and perhaps even still, I heard it often said that there is little that can be achieved with a mediator that couldn't be achieved with a traditional JSM. But speaking from personal experience, I mean, there are absolutely those cases the mediation doesn't add much value, but fundamentally there are also those cases where the mediation is actually so much better. And to my mind, where the mediation is most valuable is when it becomes part of the remedy itself, not just the route to the remedy. You'll hear from our client Sue shortly about her experiences, but if I just elaborate in the meantime, in a JSM, the discussion can be one that's quite transactional, as Joe talks about. The focus becomes whether the defendant is at fault for the injury and what the appropriate level of damages is. And even with the most compassionate and client-centred lawyers, the focus will be on that discussion that takes place between the legal teams. Maybe what the evidence is or how the court will see it, essentially who will win, who will lose ultimately. And in some situations, that might be an entirely appropriate way to resolve the dispute, but in some cases it's about so much more, and in most cases, in fact, it's about so much more. So when we let the ADR itself, such as a mediation, become part of the remedy, more than ever, we make the process all about the clients. We provide a forum for the client to explore their other aims, the other factors that motivated them to instruct lawyers in the first place. And with the right people in the room, or I should say virtual room, as we often have these days, that might be clinical leads or senior clinicians who are involved in the unit, or those certainly with the power to bring about change or provide explanations. We provide a means to resolve those issues too. And if we don't leave those discussions too late into court proceedings, then we may well meet the more needs of those who matter, who of course are the clients who have suffered the harm and the clinicians who are still reeling from mistakes and is just as keen to make sure it doesn't happen again. At this point, I'm going to invite Jasmine to come in and provide her perspective as a lawyer acting for the trust in these kind of situations. Over to you, Jasmine.
Hi there. Thanks very much. So, Guy invited me to contribute to today's discussion to give an insight into my work as a lawyer for NHS trusts, dealing with clinical claims, and to share my thoughts on collaborative working. In preparing for today, I've looked back and considered how my practice has changed over the past decade and I've thought about how practices will continue to develop over the next 5 to 10 years. I really enjoy my work, and whenever I meet someone who's considering working in the legal healthcare sector, I commend it to them. The aim to secure early settlement and pay the right amount of money to the right person at the right time drives the ethos of case management for the lawyers who work in the NHS. However, it's fair to say, even in the most careful lawyer's hands, litigation can be a brutal process for the injured or bereaved claimant, and similarly for the healthcare professionals. As a defendant lawyer, I want to involve the healthcare professionals because they are bound to help me understand the case better than if I was reading the documents in isolation. However, I'm very mindful of the fact that any amount of time I ask them to give to me to collate evidence and reflect on the events is all time away from the frontline services. As such, earlier in my career, I probably tried to avoid troubling the clinical staff until I was really clear about what I needed them to address. This would inevitably mean that they were directed to litigation-focused evidential matters rather than the wider learning and safety aspects. In the same fashion, I would rarely consider board-level involvement was necessary because I knew reporting of incidents, complaints and claims formed part of the regular governance of every NHS organisation. That was then. Now, I recognise that clinical staff, the directorate leads, boards and medical directors really want to know about the most sensitive and troubling cases from the outset, and that the most valuable learning can be secured in the immediate period after an adverse event to improve a learning culture, which is something all NHS trusts are striving for. So really, I want to think about how, as a claims lawyer, I can help facilitate that learning culture and in the process improve the pathway to resolution for a patient or family member when they are involved in a dispute with their NHS provider. To that end, I will be sharing some thoughts upon collaborative working. But before I do, I thought there was an essential element of collaboration, which involves knowing the parties and having an understanding about how they work. So I thought I would take a couple of moments to just give a slight insight into how it might be that I come to do my job each day as a defendant lawyer and how I approach a new claim or investigation. So the first time I review a claim usually follows a formal letter of claim being sent to the NHS Trust. This is after it has been investigated, assessed and presented by the claimant, who will usually have sought independent expert advice. There are specific pieces of information that ought to be mentioned in a letter of claim, but this doesn't include reference to any non-monetary aspects. At that point, I'm usually behind the claimant's lawyer in terms of understanding the issues and need to play catch up. Unfortunately, I can't usually have a very meaningful conversation with the claimant's lawyer because I need the input from clinicians and an independent opinion before being able to give advice on risks or resolution. Saying that, the exception to that might be if the NHS Trust has prepared a really strong detailed root cause analysis or serious incident review, which of course can help me focus on my assessment of risk. However, even with an account from the clinical staff and the independent expert evidence, the answer isn't always clear-cut, and medicine isn't an exact science. And there can be new points to follow up with different medical experts, or there can be a range of medical opinion, which needs to be carefully weighed up. So, say I've done all of that and I've secured the best evidence I can, I will give advice to the NHS Trust and a formal response to the claim will be provided. This could trigger discussion about compensation settlement, but there might be claims which are rebutted, and so the claimant will then decide if they withdraw or provide a letter of challenge or proceed straight to court. There are occasions when a claim is rebutted, but it is recognised there are elements of the case which warrant further consideration. For example, a mediation to facilitate a non-monetary resolution or to discuss learning with the clinician could be helpful to the claimant, even if the compensation claim will not succeed. Throughout any investigation I'm undertaking, I'm mindful of an injured claimant or bereaved family member is waiting for a response to their claim, and that the healthcare professionals involved will be concerned about potential regulatory ramifications and threat to livelihood. For those reasons, I'm keen to advise swiftly, but clinical claims are very complicated and working with clinical staff and experts to understand what and why adverse events have occurred can involve forensic consideration and collation of evidence. It is, however, fair to say that if I was equipped with more evidence at an early stage, my advice could be given with greater confidence, and this might lead to earlier resolution, whether by compensation or non-monetary remedy, reducing the adverse impact of the litigation process on the claimant and healthcare staff. So that's my little bit about what defendant lawyers might be doing. Having set that scene from a defendant's point of view, I want to think about how we can implement a more collaborative approach to clinical claims, which might serve to inform patient safety initiatives and improve the pathway to resolution for the patient or family member when they are involved in a dispute with their NHS provider. So, what I would like to see is healthcare lawyers adopting a similar learning culture to that which NHS organisations strive to achieve. When we hear from an injured or bereaved claimant, or indeed a healthcare professional, and they tell us that their experience of the litigation process was dreadful, we need to consider what could have been different or what better we can do, so that we can learn from that and adjust our approach accordingly. I'm happy to say the process is not as adversarial as it used to be, and the importance of working proportionately to avoid unnecessary costs or delays now underpins all of the litigation process. The public expense involved in clinical negligence claims is well reported, and so there is, I believe, a public duty to adopt a collaborative approach if it achieves the right outcome for your client. As officers of the court, all lawyers are expected to promote justice, and I believe developing a culture of trust and collaboration helps to facilitate just resolution of disputes. To develop this broader approach to resolution will involve a cultural shift. But there are several levers the lawyers and case handlers have at their disposal, and I thought I'd pass on a few ideas for consideration or discussion, which could facilitate the early, swift resolution we're hoping to achieve. So, from the outset, we can acknowledge there's a common goal, which would be to secure early resolution and to understand what resolution really needs to consist of. It might not be only compensation. We need to identify the core participants, the family member who might be driving the claim or a key clinician who was involved, and recognise that from the outset, which can facilitate discussion and serve to steer my investigations or the other lawyers' investigations to focus on certain substantive issues. Now, absolutely essential to working collaboratively is to understand how your colleague is working in the background. So whoever's advising the defendant or the claimant and the other parties involved, we want to know how they work, and that we need to develop a rapport and dialogue which helps both parties understand what the other is hoping to achieve. And sorry to say, but I don't think we can do that by email. Talking to each other without prejudice, if need be, is much more likely to develop trust and integrity to facilitate the collaboration. It's essential. And within those discussions, there's an opportunity to agree or seek to agree a pathway for resolution, which might encompass certain steps along the way, which lawyers can then use to narrow the issues and move the claim towards resolution without the need for formal litigation or case management directions. So, some of those steps might seem rather bold, and Guy tells me I need to include a health warning at this stage. Some of the ideas would involve a very different way of working. Others are familiar, but they could be used at an earlier stage in the process. So for starters, we could consider joint instruction of experts. There is a strong cohort of experts that we defendant and claimant lawyers tend to instruct, and they're well regarded, and they could be used for joint instruction, whether dealing with liability or quantum. There's an opportunity to share evidence earlier. If one party has a really robust independent expert report or a really strong witness statement, there would be an advantage to disclosing it early to help crystallise risks. Similarly, if the claimant can provide early disclosure of quantum evidence, this can be very helpful, even if liability is not determined. A claim could still be suitable for compromise if the quantum evidence can be shared. It will help inform proposals for settlement. And in cases where the parties hold expert evidence, early independent expert discussions could be an option. This would usually be embarked upon before trial, but in fact, once the experts' reports are available, there's not a lot of prejudice involved for the parties in asking the experts to discuss some or all of the issues at an early stage in order to help assess risks. Neutral evaluation. Oh, sorry, no, I do have another point about experts' discussion. If the experts' arguments are rather finely balanced, as they often are, it may assist for the lawyers to observe the experts' discussion to assess their performance and consider which might be preferred by the judge. Remote meetings like this are relatively simple to arrange, and it gives a valuable insight to the lawyers to work upon. Neutral evaluation is evolving and could serve to determine discrete points of dispute or whole claims. And then we have mediation, which Joe alluded to, and obviously a two-stage mediation sounds incredible. It's been well used in the past years, and its ability to offer a flexible forum to meet the parties' needs gives scope to facilitate a wider resolution. This can often involve healthcare professionals or safety and learning colleagues. Other resolution meetings and dispute resolution, which of course pre-action protocol requires us to also consider, can be used as we see fit. So once the rapport has been established, an element of resilience is required to maintain the discussion, even when hurdles arise, as they will inevitably do so. It is at that stage that the trust between parties is crucial. Hurdles which might scupper an agreed pathway or strategy or resolution ought not to undermine the overriding goal to seek to achieve resolution as swiftly as possible. So long as the dialogue remains open, there will always be an alternative pathway to adopt. As an add-on to help overcome any hurdles, in larger clinical negligence practices, the firms could identify a senior specialist healthcare lawyer who would be available to review or discuss any claims which became entrenched or stalled. In the spirit of collaboration, this would not undermine the individual practitioner, but might offer a new potential pragmatic solution. So, those strategies are potentially available to lawyers to implement on any claim without the need for formal court proceedings, and either party can make such proposals as and when they consider it would facilitate resolution. I would like to think that by taking this collaborative approach, lawyers can gain a better understanding of the issues more swiftly. This in turn helps to identify factors that contributed to shortfalls in care and helps inform any learning for the NHS Trust. At the same time, it improves our prospects of securing early resolution in whatever form that might need to be. I'm going to hand back to Guy, who's going to do a little wrap up, I think.
Yeah, thanks, Jasmine. Yeah, so just in conclusion, I mean, I'd again come back to the point that fundamentally civil litigation is the process is one that's fit for purpose, and it's not just what we do, it's how we do it that will make the difference. For me, there's no substitute for healthcare organisations getting their responses to incidents right in the first place, learning the lessons and embedding change. Good investigations will in fact identify failings which can help speed up the claims process by providing a gateway to resolution. We can see already the framework for this in the early notification scheme for maternity cases, for instance. Lawyers, as Jasmine said, are rightly proud of the work that they do for their clients in resolving these disputes and achieving wider aims. And it's within our gift to take control of the process and apply a collaborative mindset. There are no quick fixes, and the system needs to be properly resourced. Medical negligence is clearly a serious allegation, so it has to be afforded due process out of fairness for everybody involved. To my mind, a greater investment of time, money and effort at the front end of a case would actually lead to a greater cost saving in the long term, and it would help to speed up the process, it would help to capture learning and perhaps to meet more needs of those who matter most, the injured patient and their family, and of course the clinicians involved on the other side. Thanks for listening. I think now we're coming up to our end of our slot. I think probably we'll leave any questions if they've arisen to the Q&A session this afternoon. So I'll hand back to you, James.
Thank you, Guy and Jasmine, for those very powerful talks. I must say, Jasmine seems to me to be the sort of defence lawyer that I wish I'd encountered rather more often. there is a culture which is identifiable, and certainly in my long career at the bar, now over, was unfortunately encountered too often, that a defence lawyer thought that their value should be measured by the amount of aggression which they were capable of showing. My own experience, for what it's worth, is that aggression of the kind of which I speak is counterproductive entirely, and that when a chance of a reasonable settlement favourable to both sides was there and could have been achieved, the sometimes shown by defence lawyers, and I should add defence experts, was enough sometimes to make that entirely impossible. I call therefore for more lawyers to approach things as Jasmine suggests, and I'm sure Guy and other people who've acted for claimants who are listening to this event will agree with me. Collaboration, Jasmine said, much the best way, but unfortunately in my experience too often there was antagonism. And finally, in that regard, I just want to mention the single joint expert. One of the troubles, certainly in the early days, experts, I'm not saying they were limited totally to the defence, but certainly I can think of a female psychiatrist who never ever said anything other than the claimant had a head, 2 arms, 2 legs and had nothing wrong with them except they wanted money. And I can think of care experts who always played right down any of the care needs. And I can remember claimant experts who made silk purses out of every sow's ear. The single joint expert would be, in ideal terms, would be perfect as a way to solve these things. The difficulty is, who are they to be, and are they capable of being truly impartial and independent? I throw that all in because it has been a concern to me over many years, and I do think things have got a lot better. Could I pass this on now, please, and introduce Sue Lea. She's the mother of 4 boys, and in 2017 was born with severe brain damage because of mistakes made during her maternity care. She represents one of many that I have represented myself over the years, and these birth disasters and maternity disasters are, as we all know, the source of some of the biggest, most intractable problems in terms of the child in question and the mothers and the families. Despite this damage, Jasper, her son, was a bright, happy and engaged boy and brought joy to her family. But at age 2, he died of pneumonia. And since then, Sue and her husband Alex have campaigned to improve the care that's offered to mothers and babies in the NHS. And they have raised Jasper's story in many contexts to further the aim of improving that care. I hand over with pleasure to Sue Lea.
Thank you, James, and thank you very much for inviting me to speak today. I'm grateful for the opportunity to tell you Jasper's story and to talk to you about my family's experience of healthcare litigation and the lessons that I feel can be learned from that. 4 years on from Jasper's birth, I still feel surprised that I'm talking about our experience in this area and the tragic events that happened to our family. Like all families who are involved in healthcare litigation, none of us expected to be here, none of us planned for this, and almost all of us have no prior experience in this area. And this is the first point of 4 that I would like to make to you today. Next slide. When we found out that I was pregnant with Jasper, we had no idea of the life-changing impact that he would have on our lives. He was a long talked about 3rd child who, when we found out I was pregnant, we assumed would bring the same joy to our family as our 2 older boys had. My pregnancy seemed straightforward. We'd been through it twice before, and so although I felt old and tired, we weren't anxious in the way we had been the first time around. The only complication in the early stages was a low-lying placenta that was spotted on the 20-week scan. But when I was scanned again at 32 weeks, the placenta was deemed to have moved upwards, and we looked all set for a natural birth as my 2 older boys, George and Freddie, had been. It was only in the last few weeks of my pregnancy that things seemed to change. At 36 weeks, Jasper was still transverse, and so we were told by my midwife to book an appointment with the hospital to discuss our options. When I spoke to the hospital, they advised me that I should wait a couple of weeks to allow the baby the chance to get into a head-down position itself, So instead of seeing someone at 36 weeks, I finally attended a scan on the 29th of August when I was 39 weeks pregnant. The scan showed that Jasper was in fact head down, but despite what had been said at the 32-week scan, my placenta seemed to be in a low-lying position, and it looked likely that a C-section would need to be performed. My husband and I were disappointed that I couldn't have a natural birth and expressed our surprise that the placenta was low-lying, as previous scans had said it was fine. The consultant, who herself seemed quite uncertain about the results, suggested we came back in the morning to be rescanned so she could check the findings and confirm how we would need to proceed. Ended next morning as planned. The consultant was clearly running late, arriving 45 minutes after our appointment time, looking flustered and unfocused. She scanned me again and confirmed what she had said the day before. My placenta was low-lying, blocking Jasper's exit, and loops of umbilical cord were sitting beneath his head and my cervix. The consultant confirmed that I would need to have a C-section and approved this course of action with another sonographer. She then suggested I was booked in for an elective C-section in the next couple of days and advised us that if my waters broke before then, we should get to the hospital as soon as possible. We were then passed to the midwives and the surgical team, who duly booked me in for a delivery in 2 days' time and then sent me home. That night, sat in front of the television, contemplating a trip to John Lewis the next day to buy the final things we needed for the baby. My waters broke and I immediately knew the cord had prolapsed. We reacted immediately. I threw myself on the floor on all fours and my husband Alex phoned the hospital, who sent an ambulance out to get us. The journey to hospital felt so unreal, like a scene from a film or a TV drama. I remember reciting in my head over and over again, "Please be okay, please be okay." We arrived at hospital and were met by a team of midwives and surgeons. Alex struggled to keep up as I was swept through the hospital, and he missed the team checking for and finding Jasper's heartbeat. I was taken through to surgery and Alex was left alone, still not knowing whether our third child was alive or not. I started to wake from surgery. Alex thrust a picture of Jasper in front of me. It's a boy, he repeated. The next few hours are a blur, but I know that Alex explained that Jasper wasn't okay and would need to be taken to Addenbrooke's and that he would go with him. Once Jasper was prepped to leave, the team brought him in to see me and I got my first glimpse of our third son. Encased in the portable incubator, he looked so helpless and fragile. After a few moments, the team took him away and Alex stood at my bedside, clearly traumatised by having to choose between staying with his wife or going with his son, when it was clear we both desperately needed him by our side. Once Alex and Jasper had left, I remained in the hospital on my own, comforted only by the occasional visits from the midwives. Alex couldn't leave Jasper, and with no friends or family locally, there was no one who could come and support me. I remember just being shell-shocked that in the space of 12 hours, I had gone from being excited about the arrival of our baby to fearing that our newborn son might die. I was reunited with Alex and Jasper later that afternoon when I was transferred by ambulance to Addenbrooke's and our bedside vigil began. We spent 6 weeks in Addenbrooke's with Jasper, staying night after night at the hospital. At some point, we were contacted by the risk investigation team at the hospital where Jasper was born. They told us that they would be conducting an investigation into the events surrounding Jasper's birth and asked us if we wanted to be kept informed. Initially, we said that we didn't. This may seem crazy now, but at the time we were so focused on Jasper and helping him to get well that we didn't have time for anything else and didn't have the emotional capacity to think about blame. It seemed so much easier to think that what had happened to Jasper had been a tragic accident, a series of events that couldn't have been prevented, because the truth, the idea that this shouldn't have happened or could have been avoided, seemed so impossible to comprehend or process at that time. We might have maintained our belief that ignorance would help us cope better if it hadn't been for one of the consultants involved in Jasper's care at Addenbrooke's. I remember distinctly, after she had described the severity of Jasper's brain injury and the impact it would likely have on his life and ours, the look of shock on her face when I told her that the doctors knew the cord was beneath him before he was born. She didn't pause for a moment, immediately telling me we needed to take legal action against the hospital. She stressed the importance of the financial settlement for Jasper's lifelong care needs, but also the importance for both us and the hospital to fully understand what went wrong with Jasper's maternity care. Her intervention changed our approach and highlighted the naivety of our planned ignorance. We immediately contacted the hospital and asked to receive a copy of their risk investigation report. Like us, so many families don't understand the importance of healthcare litigation, the financial or restorative benefits it can bring, or just as important, the learnings and cultural change it can deliver. So it's important that there are patient-facing advocates in the system who can support families like mine who are new to this process and never planned to be here. People need to be more open about their experiences, and others need to talk freely about the benefits so families and individuals can make informed decisions should they ever have the misfortune to find themselves in this position. Next slide. I finally contacted Irwin Mitchell about what happened to Jasper at 3 a.m. one morning, about 4 weeks after he'd been discharged from hospital. Jasper was 12 weeks old and I was feeding him my breast milk through a tube in his nose while he slept. I was furious. Furious that Jasper's life was already not what it should have been. Furious that no one had bothered to contact us to discuss the horrific, life-changing events we had experienced. Furious that we had to endure our son's suffering every single day and that no one seemed to care. Furious that our life was unrecognisable while life continued as normal for the other people involved. This was the start of an array of emotions I have felt over the past few years. Anger, sadness, guilt, frustration, abject heartbreak, to name but a few. The nature of healthcare litigation means that emotions play a central role for the families involved. And in response to this, it is important that compassion and empathy must play an equally central role. Listening to Guy Forster speak today, you will be unsurprised to hear that it was his compassion and empathy that persuaded us to work with him on Jasper's case. When he visited us at our home just a few weeks after my 3 a.m. email, he was the first person who had asked to hear Jasper's story and what we had been through as a family. He asked for a picture of Jasper so his team could see who they were working on behalf of, and he promised that throughout the process he would respect the fact that caring for Jasper was our priority and would only contact us and involve us in the process when it was absolutely necessary. In contrast, the hospital never asked to hear our story when writing their risk report into what happened with Jasper's maternity care. When we engaged with them, our concerns were dismissed, our emails were ignored, and we were fobbed off by people who had very little knowledge of Jasper, the woeful care he had received, or what had been or could be done to ensure this couldn't happen to another family. Even when we finally received an apology from the chief executive, we received a formal typed letter that had clearly been written by the legal team, no offence intended, that lacked the personal empathy that was required. I understand that there is a legal due process, but the people involved in these cases have suffered enough. They should be treated with the compassion and empathy they deserve. In truth, the only way to diffuse emotions in these cases is with a human response. An emotional response should be met with an emotional response, not with dehumanised legal or formal engagement that fails to acknowledge the very human nature of these claims. Next slide. At the beginning of our litigation process, we were driven by our desire to ensure Jasper was properly provided for throughout his life. We knew from when he was just 9 days old that Jasper had suffered severe brain damage, and although the doctors were reluctant to give us a prognosis, it was clear that his quality of life would be limited. At just 5 weeks old, he was diagnosed with an aggressive form of dystonia, uncontrolled movements that twisted and contorted his body. He was given meds to control them, but they made him violently and frequently sick, dulled and sleepy. Within weeks of us returning from home, he was diagnosed with infantile spasms, an aggressive form of seizure that stopped and hindered his development further. He never learned to walk or even move independently. He never crawled, sat up, or reached for toys. He struggled to eat orally and was, for the most part, tube fed. He required care and support to do almost everything. And at that stage, it was Alex and me who did all of the caring and funded the support we needed. And yet it felt so wrong to ask for help, to monetize the support we gave him, or to ask for help to fund the additional care he and we so desperately needed. We were his parents, and we felt it was on us to support him physically and financially as we had our other boys. We felt a huge amount of guilt listing the care that we gave him that went over and above what we would normally do, because what care is ever over and above what you would do for your own child? It was only the thought of his long-term care that drove us on, the thought that if something happened to Alex and me, Jasper would need to be able to fund the support he needed. And so reluctantly, we pursued the case for Jasper, for his future. And then, just weeks after the hospital admitted liability, just after his second birthday, Jasper died. His future taken from him, taken from us, and our purpose was gone. But yet everything seemed so unfinished. We had initially privately pursued a dialogue with the hospital about the learnings from Jasper's case. We wanted to use their risk investigation as a catalyst for change within the trust to ensure that what happened to Jasper could never happen to another family. We met with representatives from the trust and set out the mistakes we felt were made and the cultural changes that needed to take place. But we were fobbed off with platitudes by two representatives who weren't across the details of Jasper's case. The tape recorder in the meeting failed to work and proper notes weren't taken. And when we were asked to give a written summary of what we had said, our emails were ignored and no one updated us as to whether action points had been completed. 2 years on from Jasper's birth, we still had no confidence that the same thing wouldn't happen to another family. We were angry that the hospital had failed to respond to us properly, and we were absolutely adamant that Jasper's death shouldn't be the end of the matter, the solution to an awkward problem for them. So we felt we had no choice but to continue with the litigation. But even then we felt so much guilt. It seemed so mercenary to pursue a financial settlement for something no amount of money could heal. And it felt immoral to pursue a legal case against the NHS. Despite our experience with Jasper's birth, I am a huge supporter of the NHS and saw firsthand the fantastic care that Jasper received from specialists throughout his life. We all know doctors and nurses do an amazing job, that we are lucky to receive such incredible care, free to all who need it. But there is a very real risk, particularly post-COVID, that we canonise an organisation. And if we hold the NHS in such high esteem, we create an organisation that becomes impossible to criticise. And that will be to the detriment of the care we all receive. Because to properly learn and improve, we have to hear about our mistakes and admit we have failings. No one should be above a reproach, and no organisation should be either. We have to change the discourse so that litigation is not action you take against the NHS, but an acceptable part of learning for our health service. That people are valued and praised for taking action that will deliver improvements for everyone. I remember a couple of years ago reading a quote from the head of NHS Resolution who said that brain damaged babies were costing the NHS millions of pounds each year. I understand the point she was trying to make, but let's be clear, brain damaged babies are not costing the NHS millions of pounds each year. Each year, the NHS is robbing hundreds of babies of the future that should have been theirs. Language matters, and if we are going to learn lessons from the thousands of litigation cases we have each year, then we have to reframe the terms of the debate. Later today, you are going to hear from Jeremy Hunt, who I believe has done more to put patient safety at the heart of the NHS than anyone else. Before him, families who raised concerns about the NHS were deemed to be troublemakers who were literally made to sit outside in the cold in front of the Department of Health offices. While things have moved on significantly since then, I still think there is much more that needs to be done to destigmatise healthcare litigation and ensure it plays a central role in NHS improvement and is not just a problem that needs to be quietly dealt with. Next slide. While the decision to pursue litigation after Jasper's death was a difficult one, it is not one we regret, and that is entirely down to the role that mediation played in our case. Once Jasper died, our main driver was our desperation to ensure that the hospital, and indeed the NHS, learned lessons from his case to ensure that no other family could suffer the same fate as ours. From the outset, we never wanted an individual to blame. Both Alex and I recognised that doctors are humans who, like all humans, make mistakes. But we believed that if we are to reduce patient harm in our hospitals, we need to build systems to ensure that when doctors or nurses do make mistakes, there are checks and balances that prevent harm being inflicted on patients. We strongly believe that the real failures in Jasper's care were in the hospital's culture and its systems, and we wanted to ensure that the hospital recognised this and made the changes that were necessary. 4 years after Jasper's birth and 2 years after he's died, we were finally able to make those arguments to the senior team at the hospital and representatives from NHS Resolution. Facilitated through our legal team, the mediation gave us the opportunity to tell our story, to provide our feedback, and to receive reassurances that changes had been implemented. Our discussions were not about financial settlements, which had been completed earlier, so we were not constricted in our conversation by ongoing legal discussions. Instead, we had a free-flowing discussion about what mattered most, understanding what had gone wrong with Jasper's care, outlining the things that we felt needed to be learned from our experience, and hearing about the improvements that had been made to maternity care at the Trust. It had taken much too long to happen, but it offered so much healing, helped us find closure, and ensured that Jasper's legacy would be that other children would not suffer in the way he had. Next slide. And finally, it is Jasper that I want to turn to. Speaking about subjects like this inevitably means I end up talking about the difficulties we face and the great sadness we have experienced. But the truth is, Jasper was the most incredible boy who brought so much joy to our lives. Jasper was kind, gentle, and patient. If he was frustrated by what he couldn't do, he never showed it. The way he dealt with the pain, constant sickness, and all too frequent illnesses was humbling. And for all of us, life ends up being about the mark you make on the world and the impact you have on others' lives. In that respect, Jasper's life was not impeded. Alex and I will forever see the world differently because of him. His friends and family feel privileged to have had him in their lives and will carry their memories of him forever. The huge grief we feel at his loss is outweighed only by the love we all share of our darling, beautiful little boy. Thank you.
Thank you. Thank you. Can you hear me? Seems to be echoing. Thank you so much. I found that intensely moving. It reminded me of many cases that I've done over the years, in which I felt, as Sue did, that what was lacking on the defence side was any sense of compassion or consideration for the intense suffering both of the children who had been harmed and of their parents, whose marriages were often destroyed, whose livelihoods were ruined because they had to give up so much time to care for them. And although I know that in my latter years I mainly acted for claimants, indeed in the end solely for claimants, I had an earlier experience of acting for the defence and was troubled in the old days by the sense that what they were about was simply trying to minimise the cost rather than in any possible way they could to minimise the damage that had been done. I have to say that I remember a leading defence barrister who was a friend of mine outside the law, who became a High Court judge. And I remember when he retired from the bar and went to the bench, he was described as having, quotes, saved the NHS many, many millions. I felt from my experience of him in court that what he'd really done was deprived a lot of very deserving claimants of the money to which they were, in fact, or should have been entitled had it not been for his extraordinary efforts. But there it is. We have to be more compassionate, and we have to remember always, as Sue quite rightly said, that those who are part in the clinical care side of disasters often feel the pain very intensely. And I remember meeting many of them in the older days who would love to have been more considerate, careful and compassionate, but somehow the system made sure they could not be so. We have to change that. And finally, I thought that message, destigmatize NHS litigation, is crucial. The idea that in some way those who sue doctors or the NHS are guilty of some terrible crime against society has to be corrected. We don't say that about the person run over by a drunk driver on a zebra crossing. We wouldn't dream of it. But for some reason, we seem to find many voices proudly alleging that that is the case when people dare to sue clinical healthcare professionals. I'm very pleased to welcome Professor Tim Draycott and Dr. Denise Chaffer to join us now and give their presentations. Professor Draycott, whom I've known for some time now, is a very distinguished obstetrician gynecologist. He jointly led the PROMPT PROMPT course implemented in over 70 countries. He's a world leader in intrapartum and maternity safety research, and is senior advisor on maternity to NHS Resolution. He co-chairs safety initiatives by the NHS Improvement and also was a founding director of the Tommy's Maternity Centre in the UK and is vice president of the Royal College of Physicians. Denise is a registered nurse and midwife by profession. She's currently Director of Safety and Learning for the NHS Resolution. She holds a PhD in healthcare as well as other degrees in management and in education. She was a professional clinical nursing leader and was Director of Nursing for the North West London area at NHS England and lead for patient safety across London. She is author of a book called Effective Leadership, A Cure for the NHS, drawing on her personal experience, very wide, lengthy personal experience in a range of senior healthcare positions. Together they make an important contribution to improving safety for patients and reducing harm. So Tim Draycott and Denise Chaffer.
So thank you very much, and thank you very much for inviting us. Can I just check, can you see the slides okay? Fantastic, thank you. So thank you very much, and also huge thanks earlier to Jo, who I've had the privilege of meeting a number of times over the last few months, and my heart goes out to her stories around the loss of Jasmine, and also a massive thanks to Sue for that very compelling story and for the care of Jasper. I'm a clinician, as you've heard by background. I'm not a lawyer. I have the role of being the Director for Safety and Learning, which is the function of NHS Resolution, which has two things to do. One is that we have to do everything we possibly can to help the NHS improve their response to harm, and secondly, to work on the prevention of harm. So I'm going to cover some of the work that we're doing at the moment in the safety and learning function more broadly, with a touch on some of the maternity initiatives, and then hand over to Tim, who's going to talk specifically around the prevention arm of our work related to maternity. Just for those of you who may not know about NHS Resolution, you've heard that referred to a number of times today. So we are the indemnifier for the NHS, and our role there, as you can see, that's our purpose. And the area that I lead is the safety and learning function. As I said, I don't work in the claims part of the organisation. We have tried over the last few years, which is one of the reasons we changed our title from being NHS Litigation Authority to NHS Resolution, to focus far more on resolution, avoid litigation, and to get much closer and upfront and upstream to the incidents that we see. In the past, traditionally, we would not know about an incident that has occurred until we receive a letter of claim. And now, particularly in the maternity space, which I'll talk about in a moment, we are able to look at these cases much closer to the incident, and that has a number of advantages. One is around helping families, patients and carers to get closer to resolution much earlier, but secondly, to extract the learning much earlier in the process, so we can feed back to organisations and help them with their improvements. So our ambition, and you'll see this is the ambition of our previous Secretary of State, who is speaking after me, is about the ambition for the NHS to be the largest learning organisation in the world. And absolutely key to this is understanding the factors that drive learning. And learning is really about maximising the learning opportunity, majoring in near misses and anticipatory factors, not waiting for harm to occur, but recognising and doing things much earlier to try and prevent harm. It is absolutely about partnership with patients, carers and staff, and it's about making sure that we capture the views of families during investigations. It's specifically about learning culture. It is about accountability, but not about blame, and it's about staff, supporting staff to be open. So this slide looks very similar to the one that was presented earlier by Joe, and this is our experience that when we talk to people that we've been working with, that we've had claims with, and we've been having feedback from, and without really any difference in the severity of the claim, this is what people are saying to us, that the patients and families overwhelmingly want an apology, and I'll go into a little bit more detail about that in a minute. They definitely want to prevent it happening to someone else, understand what's gone wrong. They want a compassionate response and signposting to support, and particularly for the areas where compensation may be needed, that people are given the opportunity and the signposting to be able to find where they need to go for that and get that information quickly. And understandably, the staff want something very similar. And what we often hear with staff is that they can be involved in incidents. They can actually be quite very severe reactions to having been involved in an incident where harm has occurred. And often they may write statements, they may attend meetings, but actually they don't always get the opportunity to find out what's happened, and sometimes they don't get the opportunity to give these apologies. What we're trying to do in the Safety and Learning team is build resources about how we can improve response to harm and how we can reach out to some of our patients, families and carers to help us more in this space. We have produced our Saying Sorry guidance, which has been part of the organisation for some years now. We have the duty of candour, but actually what we're finding is that many organisations need much more help in absolutely exercising the duty of candour. We, as you've heard, we do provide mediation, and Beverly Hunt, who was part of the mediation that Sue referred to, is part of my team. So what we're trying to do is have a safety and learning component part of mediation, but also to look at what we can explore in point of harm support and facilitation as well, before things ever go near a claim, particularly in the very early parts of a harm event. We produced some guidance for staff, which I will give a little bit more detail about, and we've also produced some joint guidance with GIRF, which is the Getting It Right First Time team, with NHS Improvement, NHS England, to try and help organisations improve their responses to the way that they handle claims. And we also provide data for trusts by specialty to look at the areas that they have claims in, and for them to really focus on whether they can look at how those link to their complaints and their incidents, and to see whether there's some factors that they can put in place to prevent harm occurring. This is our leaflet about saying sorry. It's been around for quite a long time, but we continually say this. Our chief exec says this very publicly, that saying sorry is always the right thing to do. And one of the things that we often hear back from families is the way in which people say sorry is incredibly important. They are saying, I'm sorry you feel like that is not an apology. What we're asking organisations to do is for their clinicians and frontline staff to commit to saying they're sorry that something happened, sorry for the distrust, that they're going to commit to investigate and to learn from that. And often what we find is that those apologies need to happen more than once, more than on one occasion, and they need to be followed up and contact with families to continue. This is a public statement from our Chief Executive that we show at every opportunity to our organisations, which is very, very specific on this. We will have never and will never refuse cover on a claim because an apology is being given. Just a slide here around maternity. And as you can see, the actual cases of cerebral palsy are beginning to reduce slightly. What we're seeing is that the cost of those is going up. And one of the things that we talk a lot about is the harm and the impact that these harm events have on families are, as we've heard, absolutely huge. But what we want to do is everything we possibly can is to prevent these cases from occurring, so that we can really get our handle on how we can do better in this space. A bit more about that from Tim. So a couple of initiatives that we've introduced. So we've introduced an early notification scheme for maternity harm in 2000. Well, we updated the aims from 2021. We're in the 4th year of the scheme. We are, instead of waiting to receive a claim from a baby with a brain injury, sometimes several years down the line, we're asking for the trust to notify us within 30 days of that incident occurring, and we're working very closely with the Healthcare Safety Investigation branch on the investigation part of that, and then how we can help the families have an early liability investigation so that they can get earlier access to compensation. This also has the benefit of being able to feedback in a much more timely, at the time of incident space, to do whatever we can to feedback the themes of what's gone wrong and what they need to do to put the things right. The other initiative in maternity is the Clinical Negligence Scheme, the Maternity Incentive Scheme. And this scheme now is in its 4th year. And this is driven from our 2 national maternity champions, Matthew Jolly and Jackie Dunkley-Bent, who have worked with us. We administered the scheme on behalf of the Secretary of State to look at what are 10 actions that trusts can take to drive improvement in maternity. And those range from having the right workforce for training, education, work around the Embrace work, which is perinatal mortality tool that is used, involvement with families. Our own action is about early notification scheme, making sure that we have 100% reporting to the scheme. And you will see here for this very crowded slide, there are a number of organisations that are part of this incentive scheme. So this ranges from making sure we've got the right data reported, that we have the right workforce, that we have the right training, and that we have patient and parent involvement in those processes and opportunity for feedback within the organisations. Within our own action, which is action 10, there is a duty to ensure that families are informed on the role of both HSIB and the early notification scheme, and that there has been compliance with the duty of candour. One of the things that we talk around the duty of candour is it's really very, very important that there are continued conversations and continued opportunities for families to ask questions. It's not a one-off event. This is a document that we have produced with a range of stakeholders where we are trying to look at addressing the variation that occurs across a number of NHS trusts for staff when they're involved in incidents. We often hear that some of the staff are fearful. They're certainly fearful of the responses of their own organisation if they've been involved in a harm event. And what this document sets out to do is provide a consistent framework for working through serious incidents and the processes that staff can be supported through. And it's about putting the patients, the parents, the carers and the staff into the same space. And you heard earlier the work that Joe was talking about, and this is very much building on the Sidney Dekker work, Restorative Justice, which is about who is hurt and whose responsibility is it to address that harm. And what we're trying to do with this document, which is also supported by AVMA and our Speak Up Guardian, is put the patient at the centre of learning from incidents, but making sure that staff are treated fairly, equitably, they follow processes so that we focus on a learning process and not one of blame. And then the final slide for me is just showing you some other work that we're involved in my team. So we will be producing a second report of the early notification scheme, and you're going to hear a little bit more from Tim about the impact of our first report on improvements. We are in the process of near publishing of a review of the reviews of emergency care claims. We've also recently into a final draft of our first year experience of the CNS GP claims. We've got some work on patients with diabetes and lower limb complications. We're interested in claims related specifically to that of interest to nursing, falls, pressure ulcers, ambulance provider claims, and we look at potential claims that result in assaults on staff, and we are also focusing on those claims where there may have been some diagnostic overshadowing with families with children with this learning disability, and how we can take the fair and learning culture work forward. These are an example of some of the products that are available. They're all publicly available on our website. I'd like to just draw particular attention to Nadine's story. So Nadine Montgomery's story is a very, very compelling video of the story of Nadine's experience. And whilst that may be a video about consent, it is also fundamentally one about candour, openness. And if you listen to Nadine's story, what a difference it might have meant if somebody had spoken to her, put her arms around Nadine right at the point of incident and committed to learn from what happened in her case. So at this point, I'm going to hand over to Tim, who's going to talk far more about the preventative arm of our work. Thank you for listening.
Look, delighted and really privileged to listen to everyone's story this morning. Joanne and Sue, really important that we engage and we listen and we work together to plot a way forward to better care. And I'm going to talk about that again today. So thanks very much, James, who presented. I have a number of hats in this space, but today I'm going to be speaking as the maternity lead at NHS Resolution. Next slide, thanks, Thijs. So I'm just going to really focus on NHS Resolution and kind of how we might improve care across the system. Of course, NHS Resolution is all things maternity. It's a real big issue for us. There's litigation, there are kind of safety initiatives, and what's the impact on our service. I'm going to describe a number of current innovations in maternity improvement, but I think that the main message of my talk is how can we work as a system to amplify effect? How can we work from all aspects of care, from women to Whitehall, to get everyone engaged and everyone moving in the same direction to improve care, for everyone at the coalface. So next slide, thanks, Thijs. I think just my view of NHS Resolution, and remember I'm a working obstetrician, I work in Bristol, and my view is that in some ways indemnifiers can join up this system, join up exactly what I said about all levels of the system, from women to Whitehall. And I think one of the useful things I think NHS Resolution has done or started to do is kind of catalyse this kind of collaboration of NHS bodies, practitioners, colleges, academics. Now, I'm sure most of the general public think, well, why wasn't that happening before? And that is a valid criticism, but I think we are moving forward. And I think there are opportunities for us to kind of align and focus, to really build on successes, and everyone playing to their strengths in this space that I don't think's happened before. And I think by doing that, we can work all together, as I said, right across from women to Whitehall to improve care together. Next one, thanks. I think there, you might say, well, golly, people have been talking about that for a long time. You know, why is it going to be different now? I think there have been some really important new research and insights based at least partly on NHS Resolution findings and reports for us to be able to define what safe maternity care looks like so we can replicate it. What we've really done some work to try and understand, why is fetal monitoring so difficult? Why is it so difficult to listen to women and auscultate the baby's heart rate and do the right thing in labour? I'm going to talk briefly about a DH funding programme for avoiding brain injury in childbirth, which is both fetal monitoring and also this new issue of impacted fetal head at caesarean section. Next one, thanks, Thijs. So this is a piece of work that was recently done led by Mary Dixon Woods and her group at Cambridge, looking, instead of just, one of the problems we have in maternity care is we constantly look at, why are things unsafe? Why did it go wrong? What happened here? We don't very often look at, okay, why are some units doing this very well? What is it about those units? Because those units might be able to give us the answers to the problems we've identified elsewhere. And what we saw in this kind of positive deviance model is that there are definitely social, organisation and cultural factors that make some units much more functional than others. Local training seems to make a big difference. Staffing levels makes a big difference. And certainly the physical environment. I'm sure many of us have noted that maternity services are often slightly distant from the main hospital, and we're not quite as looked after sometimes as we could and should be. Next one, thanks. So why is fetal monitoring so difficult? Well, it's interesting because we've struggled this for many years, and unfortunately, up until recently, the only solutions people have been able to provide are technical solutions. Can we get computer-aided decision making? Can we get computers to have a look at traces? But actually, I think what's becoming more of an issue is that we're understanding it's what humans do with machines, both staff and women in labour, as well as machines. And what we did was, look, we did 400 hours of ethnography where ethnographers, non-clinical people, sat in labour ward rooms watching how we interacted with people in labour, and also how staff interacted with the machines, etc., etc. And what we identified was there are issues with staffing, the machines themselves. There's very poor standardization. Okay, and there wasn't very much shared decision making. And I think one of the key issues we're going to have to get back to is understanding all perspectives in this situation. But I think it is helping us move forward towards new solutions. Next one, thanks, Thijs. And I think if we're going to have a look at fetal monitoring in practice, we've got to address all of these kind of 8 big problems we identified. Can we standardize equipment? Can we train people to do the right thing slightly more consistently? Can we work better as teams? Can we actually even out the workload a tiny bit? One of the problems of maternity care, of course, is it's very difficult to schedule, but we've got to be better and more agile at that. I think we've got to think about hierarchy and task division, communication, escalation, a big issue, and also the processes by which we care for women in labour. Next one, thanks. So the Avoiding Brain Injuries in Childbirth programme that's recently been funded by the DH and is just in a consensus building stage at the moment is both fetal monitoring and impacted fetal head at caesarean section. I'll talk briefly about both. But one of the problems with fetal monitoring at the moment is that there's no standardized system for national application. And we're going to build a consensus around how we should do that. We have already modeled the tool to understand what effect it might have. And we've done a really big piece of work on parallel stakeholder engagement using a special digital platform from this institute in Cambridge. And that in particular has helped us engage with nearly 150 parents and getting on for 400 maternity staff to try and start to build a consensus around this. Impact of fetal head at cesarean section I'll talk about too, but it is now a rapidly emerging problem, first identified interestingly by NHS Resolution, and the RCG, the RCM and DH are now working towards this systematic review of management and an evidence-based algorithm, and I'm going to show some of the tiny bits of work we've done around that. Next one, thank you. So one of the big things we're really trying to do, and this is about active listening. How do we co-design in a much more active way than we've done before? And if anyone wants the address for the digital platform afterwards, we're really keen for everyone and anyone to contribute. We're really interested in listening to as many voices as possible to build a really broad consensus about how we move forward. Then we can co-design and optimize interventions using these kind of large-scale, rapid cycle tests of change. And I think we've really got an opportunity to listen as broadly as possible, but co-design the future. Next one, thanks, Dice. So impacted fetal head, it seems to be a really emerging issue where people find it very difficult to deliver the baby's head at cesarean section, and it's causing a lot of problems, interestingly, and is now 9%, a condition that really wasn't so well recognised when I was a registrar, but is very well recognised today. And although it's the same sort of prevalence as shoulder dystocia, there are no protocols for the treatment and management of impacted fetal head, and that's what we're working on with the ABC programme. Next one, thanks, Thais. So in particular, we've got a prototype algorithm that's being tested now and is being reviewed using our consensus building network methods. And we also, Thais, I don't know if you can click on that picture, but you may also be able to see some augmented reality that we are doing. There you go. And you can, is it working? No. Okay, so it's a really important piece of work where we can actually use augmented reality to help people learn and teach and understand the problem they're trying to solve. So even really looking forward to new ways of doing things better. Next one, thanks, Thais. So, but what we also know is that some units, in fact, the units who stand to benefit the most from some of these interventions are least able to take them on. And let's not hide that. Let's not, let's do something positive about it. So one of the things we're trying to do is actually learn from the literature and develop support options at unit level so we can be absolutely as sure as we can be to get a consistent, effective implementation. Next one, thanks, Thais. So what's NHS Resolution's role in improvement? Well, I think the litigation process, that's not for me. Both my parents are lawyers, that's why I did medicine, but that is an important thing we need to have a think about. But I think what we can do on the clinical side is continue our analysis of claims, understanding it's quite a narrow lens, but catalyse system level improvements, support national research into the evidence base for improvement, and I think curate and incentivise the evidence-based interventions that using the systems Denise was talking about. And what we want most is the broadest possible engagement and co-design moving forward. Thank you very much. Thank
you very much, Denise and Tim. it's very heartening and encouraging to know how much concern and care is going into the sort of work just described to us by people in a very powerful position to bring about change. And when we come to powerful positions, I'm very, very happy and pleased to welcome Jeremy Hunt as our next speaker. All of us will be very familiar with his name and also with the work that he's done historically. He's been an MP since 2005. He was previously, in 2010, made Secretary of State for Culture and presided over the Olympics and the Paralympics, which was such a success. And then from 2012 to 2018, he became and remained the longest serving Secretary of State for Health in our political history. Such, he was in a position to make real change and did so in many ways, some of them I know contentious. And he was then fairly briefly Secretary of State for Foreign Affairs, but is now chair of the House of Commons Health and Social Care Select Committee, which is at the centre and the heart of so much of what we've been talking about today. We're extremely pleased to welcome him. Thank him very much for coming, and I'll hand over to Jeremy Hunt.
Thank you very much indeed, James, and it's a pleasure and a privilege to take part in this webinar, and it's a particular pleasure to come after Tim Draycott. Tim was a huge inspiration to me when I was Health Secretary, and he really helped me to understand how we can make huge progress in reducing the amount of avoidable harm or death just by very simply spreading best practice and making sure that our average hospitals follow the practices that Tim pioneered at Southmead. And so it's wonderful to come after Tim, also to come after Sue Lea or Sue Beebe. I'm not sure whether she presented to you under her maiden name or her married name, but Sue worked for me for many years in both the Department of Culture and the Department of Health, suffered her own terrible tragedy, and in a way, it was one of the most horrible ironies that, having campaigned with me on patient safety, she then saw the very worst thing that can go wrong. So it's wonderful to come after Sue. When I arrived at the Department of Health in September 2012, I really knew very little about health policy. I'd been an NHS patient all my life, but thankfully pretty healthy. I'd had 2 kids born on the NHS, but health policy was not an area that I'd really specialised in Parliament or in government. But the first crisis that I had to deal with was mid-staffs. And I started talking to both families who'd suffered at mid-staffs and also NHS managers and NHS leaders who had been responsible at the time of mid-staffs. And I had a very striking conversation with Sir David Nicholson, who was then Chief Executive of the NHS, who said to me, and I'll never forget this, he said, Jeremy, you have to understand that in healthcare, we harm 10% of patients. It's sort of the cost of doing business, if you like. I was quite shocked by that. It's a large number. And I said, well, how many people actually die because of medical error? And being the good old NHS, we'd actually done lots of academic surveys on this, and there was a survey by Helen Hogan and Nick Black that said that about 4% of hospital deaths had a 50% or more chance of being preventable. And if you actually, and I then said, well, let's just tell me how many is that in hard numbers? And it worked out at about 150 preventable deaths every week in the NHS in England. And those numbers were derived by getting a couple of completely independent doctors to look through the case notes of patients who had died in hospitals and come to an independent view. And they came to this view that on that basis, around 150 preventable deaths every week. This is not, it's very important to say, an NHS issue. This is a global issue, and I head the World Health Organization's Patient Safety Steering Group. I co-chair that with the Deputy Director General of the World Health Organization. And they say that medical error is one of the top 10 killers worldwide, responsible for more deaths annually than malaria or TB, in fact responsible for 2.6 million deaths annually across the world. And I think one of the reasons why we tolerate this high level of preventable death in healthcare is because there is so much death anyway. About half of us die in hospital, and if you take an average district general hospital, they will have about 50 deaths every week. So those mortuaries are busy places. And if you're told when you're running that hospital that one or two of those 50 deaths were preventable, you don't really want to spend an enormous amount of time trying to work out which one it was. It feels like a kind of needle in haystack job. You'd rather put all your effort into dealing with the patients that are alive and that you're trying to save currently in your hospital. And I think what's happened in healthcare is we have developed a tolerance to death and to avoidable death that is much, much too high. And to understand the root cause of the problem, I think you then have to try and move from the general level of statistics that I was operating at as health secretary and actually try and put yourself in the shoes of individuals on the ground when these terrible tragedies happen. And you've heard this morning what it's like for a family. I just want to talk about what it's like for doctors and nurses involved in these tragedies. Professor Albert Wu of Johns Hopkins University, who is a very eminent global campaigner on patient safety, coined the phrase second victim. And what he was basically saying was that when a patient dies as a result of a mistake, it is one of the most traumatic things that can happen to any doctor, nurse, midwife. And unlike everyone else, they have to go back into work the next day. And all sorts of things at the point when that happened then start to go wrong. One of the things is that our natural psychological defenses kick in. There's something that psychologists call the memory illusion, where we start to misremember things, to actually change our memories of events, because the psychological consequence of admitting to ourselves that we may have made a mistake that cost someone else their life is so huge that as a coping mechanism, sometimes we just try and change our memory of what happened. And I remember having a lunch with Professor Sir Bruce Keogh, who was medical director of the NHS when I was health secretary, and he was a heart surgeon, and he told me how one of his patients had died on the table in front of him, one of the most traumatic things for any surgeon to cope with. And his colleagues gathered round him and said, Bruce, he had a very, very bad heart, the patient, and he was going to die, and there was nothing you could have done about that. To which Bruce replied, yes, but he wasn't going to die on Tuesday. And I think what happens is there is a tendency to try and explain away mistakes. But then some other things go wrong too. Because even if you have a doctor or a nurse or a midwife that wants to be completely open and transparent, and most of them, that is their starting point, they then start to think about the professional consequences. And because in medicine, we don't really have a very solid, foolproof system for distinguishing between the everyday mistakes that any human being can make, but that sometimes in medicine have tragic consequences, with egregious responses that lawyers would call gross negligence. Many frontline clinicians worry that if they own up to what could have been the kind of mistake that anyone could make, it will be categorized as gross negligence and their career will be over. So many of you will have heard of James Titcombe, who's an extraordinary patient safety campaigner, and he lost his son Joshua because essentially the midwives responsible for Joshua's care didn't spot that his temperature was low, and that's an early warning signal for a red flag for sepsis. But when the investigation was done, Joshua's temperature charts had somehow magically been mislaid. Presumably they were destroyed, and that is, that is a totally sackable offence for any clinician. So why would those midwives have done that? Well, you can say that maybe they were unethical, but it may also have been that they thought that if those temperature charts are discovered, we will definitely lose our careers, so it's safer to take the risk of destroying them, and maybe no one will find out how they were destroyed, and then maybe we'll be okay. And this is where you start to get this web of lies that surround some of these tragedies. And the most important thing of all, which is that you learn from a mistake so that it's not repeated, becomes the one thing that doesn't happen. And you put on top of that a tendency, still I'm afraid, in a lot of hospitals to decide the easiest course of action if something does go wrong is just to fire one individual, the kind of rotten apple approach. And that allows you to say publicly, we had a problem, we fired this member of staff, the problem's been addressed, we can move on. But of course, it also can often mean you've actually ducked the problem, which was a structural issue, exactly the kind of structural issue that Tim Draycott is trying to solve through his prompt training system. And so exactly the same mistake could occur again when another nurse, another midwife, another doctor makes the same mistake, because you haven't done the most important thing, which is to iron out the possibility of that mistake being made by anyone in the first place. So all these things conspire to mean that tragedies end up being repeated, and that we have this tolerance of avoidable death and avoidable harm in healthcare that is much too high. What are the solutions? Well, the first solution is what you've been hearing this morning from people like Tim Draycott, which is to absolutely make sure that we learn from best practice, that we spread best practice. And in 2017, I launched a national campaign to halve the number of neonatal deaths, severe neonatal injuries, stillbirths and maternal deaths. And we have made some very good progress, and the latest figures are that between 2012 and 2019, the number of neonatal deaths has gone down by 770 a year. So I think, and I hope people like Tim would agree, that we are making progress in spreading best practice throughout the NHS using things like the prompt programme. But I also think we need to reflect on whether we need litigation reform, clinical negligence reform, because countries like Sweden have neonatal death rates around half of ours. So if we had the Swedish neonatal death rate, 1,000 more babies would survive every year in England. And one of the reasons that that happens in Sweden is because when a child is born severely disabled, they are able to access compensation without having to get a court to agree that there was clinical negligence either by a hospital or by a clinician. In Sweden, you get that compensation as long as the clinicians agree that a mistake was made. They don't have to accept there's clinical negligence. And I worry that in our current system, what happens is that because a family, when a severely disabled child is born, completely understandably are keen to get compensation because they of the huge financial implications for the rest of their life in terms of bringing up a disabled child, they're then told the only way you'll get that compensation is by proving clinical negligence. And so lawyers get involved very quickly. And that means that these structures that we talked about, where people close down and don't talk about what happened and don't learn from what went wrong, become reinforced. and for the most difficult cases, you can take easily 5 years on a difficult case, and that's 5 years when people are fighting things out in the courts, not trying to get to the bottom of what happened quickly, and most importantly, spread the knowledge of that so that you can avoid that happening in other places. So that's what my select committee has recommended needs to be changed. We need to look at the way the Swedish system, and in fact not just Sweden, but I think other Nordic systems, and indeed Japan has done some similar reforms for children born with cerebral palsy. I hope we consider that, but I don't want to suggest that clinical negligence reform is a silver bullet. The hard graft of reducing the number of terrible tragedies that we still have every day across the NHS is going to be by creating a culture of learning and openness that people like Tim Draycott pioneer, and improving clinical practice to stop these accidents happening in the first place. But we should try everything, and if we're really going to give people the safest, best care possible in the NHS, that should be our top priority. Thank you, James. I'll leave it for there, and we can go on to our discussion.
We were so encouraged to hear you talk in those terms, and it is very heartening, as I said earlier, to hear so many people talking as if we really all did have a common aim and goal in reducing the number of mistakes made in clinical care environments, and also in dealing more compassionately and more swiftly with those who suffer from them. I just wanted to repeat, however, before we go on to our question and answer session, something I feel very strongly about and that I mentioned at the beginning. There is, to my mind, innately wrong about addressing the appalling number of mistakes which are made in clinical care in this country with such a toll of suffering through the amount that it costs the NHS. The real focus of all that attention should be the cost in human suffering, and once that's addressed, that's the first priority, but we then make an equal priority the importance of reducing, minimizing, reducing almost to zero so far as is possible the number of avoidable mistakes that are made. And it does seem to me very important to hear people like Jeremy talking in the terms that he did, because too many politicians, too many newspapers, too many commentators spend their whole time complaining about the cost in damages and legal costs, when of course their cost only arises because the mistakes have been made. And it only arises when mistakes have been made that should never have been made, had reasonable care been exercised. And it is very bizarre to hear bellyaching, excuse the expression, in the House of Commons and elsewhere, about closing down wards because of the amount of damages and costs that are paid out, when the bellyaching ought to be about the enormous cost in human suffering of mistakes that ought to have been avoided. And to hear Tim and Denise and, of course, all our speakers today seem to me, above all, to make that point as forcibly as it possibly can be made. And as I said, when somebody's run over by a very careless driver, you don't start blaming the victim, you don't start blaming the lawyers, you don't start bellyaching about the cost of the damages. You start saying we must address careless driving, and if it's partly the road's fault, we must address safety on the roads. Anyway, I know it's a rant of mine, but I'm sure Jeremy and others won't mind me just repeating those points, because they seem to me to be absolutely central to the issues we're discussing. Now, I know there are a number of questions and answers, questions which have been asked. Some of them were submitted in advance, and since they've taken the trouble to send them in advance, perhaps I could ask all our speakers to look at them quickly now. Does anyone think there's scope for expanding the early notification scheme is the first question. I don't know whether Tim might be the first one to answer that.
I think Denise would be ideally placed for that, James.
Sorry, yes, I should have said Denise, really.
That's fine, thank you, and thanks very much. I'm having a slight signal problem, so I hope that you can hear me. So at the moment, the early notification scheme is we've we've basically established the early notification scheme within the existing legal framework. So we've done everything we possibly can to get early notification, get early to the to knowing about the case, to get an early liability investigation and get compensation as early as possible, so that, you know, we've massively reduced the amount of time, whereas previously traditionally we'd wait for a letter of claim. What we need to do really is an evaluation of the impact of that scheme. The secondary kind of purpose of the scheme is to extract that learning and to do everything we possibly can to prevent harm. And I think you've heard from Tim really some real concrete things that we found in getting very close to those cases right now, and particularly, instead of keep saying fix fetal monitoring, understand what is it we need to do that is driving the problems of fetal monitoring. So evaluation is key. The timing of the evaluation will need to happen, and also the parents' experience of that. And I think we have started to evolve the scheme, listen to feedback. The emergence of HSIB has been very, very important to the scheme, because they do the early independent investigation before that comes to us. So before we start to expand further, we have to really know that this is benefiting the people we're here to serve, that it is doing the aims of the scheme, so getting early investigation, early compensation, and it is ensuring the learning is happening in a timely way and we're making the changes. One of the real benefits, I think, as Tim said, in terms of being seen, I think, as a system integrator, we can drive some of the improvements that come out of the EN experience through the maternity incentive scheme, and we can look at whether people are putting those changes in place. But I would think at this point we just have to make sure that we evaluate at exactly the right time to make sure that this is the right thing to be doing. I don't know if Tim might want to add to that.
No, I think we do have to get a broader view of the scheme and make sure we are in the right place. But I think the early results that are going to be provided in the next report, and is this year's report, I think are extremely encouraging. We can get to a much quicker resolution than we have before, and I think that's better for everyone in the system.
If I could just come in on that as well, but I mean, from my perspective, it's really interesting, Denise, to see and to hear you speak about how much it's evolved for our patients that are involved in that environment. It really has become, I think, it started off as a process by which these incidents were obviously highlighted really early on to trust in the NHSR, but I think as things become more transparent, that actually it has a real value in meeting those needs that we talk about in Sue and Joe's slot as well. To my mind, that there is real potential to expand the scheme. I mean, at the moment, it's very much based upon the framework that we're given by the Each Baby Counts work, but if we can get to a point where these investigations are so thorough, comprehensive, and actually drive proper learning, then we could use those as a gateway to resolving the cases a lot more quickly than we currently do, and that's got to be in everybody's interest.
Well, thanks for those answers. Can I move on to another question, which is this: patient safety can be improved by clinicians following nationally approved guidelines. What action can be taken to ensure that that happens? By which I think they are referring in particular to sort of protocols and NICE guidelines which exist.
Yeah, I'm going to fall on my sword for this one, James. This is, I'm sure, as the only working clinician here. So it's a really important point, and I think a really important point about implementation. I think, so I always say, and Jeremy very kindly has referred to some of the prompt work we've done in the past, but I've always said, let's make the right way the easy way. Let's give people the tools and simple systems to make implementing national guidance at the coalface, in fact, the easiest thing to do. And we can't just expect to, I mean, I'm, Vice President of the RCOG, I write guidelines every day, but the big issue for us is how do you get this piece of paper here to improve care for Sue and Joanne? Both of you, there are guidelines for both your two stories today. No question about it. So how come they weren't followed? So I don't think it's just about punishment or incentives. I think it's actually about making simple tools and simple systems that make it easy for people to provide the right care. Secondly, how do we include parents in knowing, okay, what should your care be? There's a fascinating piece of work by TAMBA, the Twins and Multiple Births charity, where they told women, this is the care you should expect in your twins pregnancy. And they halved the rate of stillbirth because women could demand the care that was required. So I think there are some simple things we can do. I think there are some broader things we can do, but it's not just about punishment and new guidance. It's about much more sophisticated ways of engaging with women and simple tools to make it easy to do the right thing.
Can I just come in on that point? Because I think what Tim said is really, really important, and empowering women and mothers to understand what their care should look like is really, really important. And we had this within our case where, you know, when they did the serious investigation report, that it said in the report that we had been advised of the risks of going home that day, and which was just not the case. We had been told to get to hospital as soon as possible, but given no more information than that. If someone at some point had said to us, there is a real risk here that your child could be born with a serious brain injury, we wouldn't have walked out that door of the hospital. We just wouldn't have done that. And I think there's a case for being much more honest with parents and expectant parents about what their maternity care should look like and what they should expect from that process, because I still hear stories now which I think are terrifying, where people have been told, you know, don't worry about this, go home, you know, babies who are transversed, give them the opportunity to move head down, all of those things, which is just crazy advice. And if parents were actually warned about the real risks that are involved, then they wouldn't allow those that guidance that they're given to go unquestioned.
I find myself strong, as Sue's just said. I also just want to say quickly about guidelines. I've often been asked by doctors, if I follow them, am I immune from a negligence claim? Or if I don't follow them, is it automatic that I will be convicted of negligence? And it's, of course, very difficult to answer those questions because obviously, generally speaking, it is best and advisable to follow the guidelines. But then again, of course, it can produce a tick box mentality in carers and the failure to look at the given patient in front of them at the given moment. Oh, this has happened, so I'll follow the next box. Oh, I do that, whether it's a fetal blood scout sample or whatever it might be. And I therefore think there is a problem slightly about the idea that somehow everybody religiously following very precise guidelines will solve all the problems that we face.
I agree with you, but guidelines are not, that's the purpose of guidelines is to synthesize the evidence to provide information on the best possible care. They're not completely prescriptive. And Joanne in her talk this morning said, let's, you know, it wasn't quite let's make the right way the easy way, but it's kind of let's make it right. Let's make it the right way a bit more often. And I think sometimes, and you know, look at the Montgomery work you've done, James, you know, with Nadine. I think that's really helped us say, okay, look, everything is paternalistic if you're not careful. It's just as paternalistic to deny the risks and say you're going to be normal, off you go, don't do anything, as it is for me to say, you know, you must have a cesarean. These are decisions that need to be made together. And I always say, you know, you're allowed to drive a Volvo, you're allowed to drive a motorbike. They're both completely valid options, but you've just got to understand the pros and cons either way. And my job is to help you navigate through those, not to tell you what vehicle to drive. And I think we can only do that by working with Sue, Joanne, yeah, the whole team. A bit Guy maybe, but more Sue and Joanne. But yeah, to try and have a think about what does that look like? How can we do that? And one of the things we're doing in fetal monitoring is asking women, okay, how do you want us to describe when we're worried that your baby is starting to struggle in labour? How do you want us to describe that? Because I think I know what I've said for 20 years as a consultant, but maybe I'm completely wrong. So this is my point about listening to Joanne, Sue, everyone else, to say, okay, help us understand how we can do this better.
About the protocols and guidelines. There is a very popular line taken in defending cases nowadays that what happened was a systems failure. And the contribution of the guidelines, of course, has a further effect on reducing the sense of personal responsibility among the staff. First of all, if you resort to it's a systems failure, you entirely negate the idea of personal accountability and responsibility. And all professionals know they must accept a degree of that. And what's more, the idea that the guideline is, in a sense, the guide, the mentor to everything. As Tim says, it must never be that. It's not prescriptive. We're not standard issue. If patients were standard issue, then it would all be so much simpler, wouldn't it? Patient safety is, of course, the entire focus of our discussion today. There is a question which asks about the duty of candour. It was introduced with such a wave of enthusiasm, but the questioner says for some reason the application of this duty varies across the country. What is it that prevents those responsible from being more transparent and candid with families and patients? I wonder who'd like to answer that. Jeremy?
So I think the general view about the duty of candour is that it has been a step in the right direction, but it hasn't been as transformational as people hoped. And I think the reason for that is because there is a very big variation in hospitals in terms of the extent to which they have a learning culture. I think there are a number of fantastic hospitals where they understand that candour and openness is a vital step towards improved patient care, but there are still far too many places where there's a blame culture. And so they actually think that maybe the management of their hospital do not want them to be open about mistakes that have been made, and they worry that the consequences for them personally will be very severe if they are. I wonder if, while I've got the floor, if I could just make a couple of comments about some other things that have just been said by the panel. First of all, I think one of the biggest mistakes people make when they look at the NHS from the outside is because it is the 5th largest organisation in the world, we tend to think it is a pyramid where someone at the top of the pyramid can ask for something to be done and it automatically happens in 250 hospitals. I think I learned and Sue learned the hard way that that doesn't actually happen. And the reality is that if the air accident investigation branch says that you need to stop using this kind of fuse on this kind of type of electric circuit on this type of Boeing jet, then within a week, every airline in the world will stop using that fuse because they don't want their planes to crash. But if the NHS issues a guideline from the centre saying that to avoid this type of tragic accident, it's absolutely essential in every situation that all midwives do X, it will be ignored. And the reason is because all those midwives are incredibly busy. They're rushed off their feet, trying to deal with the problems in front of them. And they're getting thousands of other guidelines being instructed to them every week. If you actually look at the number of instructions that the medical director of the hospital gets every week, they are so numerous that in the end they have to make a judgment. So the art is exactly what Tim said. It's not about instructions from on high. It's about changing processes so that as you say, Tim, the right thing is the easy thing to do. And that's why I think it's wrong, if I may be so bold, James, to say that there's a contradiction between talking about personal responsibility and system issues. You always have personal responsibility to deliver the safest possible care, and nothing should ever detract from that. But when something goes wrong, I think it's really important to understand, is this the kind of mistake that in that situation any well-meaning person could have made, in which case we need to change the system to make it more difficult for other people to make that mistake? Or is it a mistake that that particular person made because they were incompetent? And I think 99 times out of 100, it's the former, not the latter. But the problem is, because of the blame culture, and because it actually lets the hospital off the hook to fire one midwife or one doctor, they're quite tempted to say it's the latter, and then they don't have to go through the hard graft of changing the systems to make it more difficult for people to do the wrong thing the next time. But I think high performing organisations with the highest, with the lowest death rates and the lowest injury rates are the ones that do take that trouble to improve their systems to try and make it more difficult to do the wrong thing next time.
So I'm very glad. I think I perhaps only meant there's a tension between responsibility rather than that each or one cancels the other. What I should do is ask, anyone else got another comment on the duty of candour? Denise.
Yeah, so I agree with some of that. I think we are seeing some improvements. So I think some of the work we've done on the being fair work and the disproportionate variation around disciplinaries is changing. So I think we are seeing some improvements in that, and in terms of driving improvements in the culture. I think one of the difficulties with the duty of candour is there's a risk of it being a process and people missing the point. So I always think that we always talk to frontline staff about, does it feel like we're all patients, we're all relatives, what would we want? We don't necessarily want a category of severe harm that triggers cancer. We want to be treated in a compassionate way with honesty, openness, transparency, support. And so I think in my experience over the years, actually, our families and patients and carers are pretty forgiving as long as people are open and honest and supportive, and they put the support networks around people. The sort of example that you gave, Jeremy, where there feels like there's been cover up or people, you know, removing documents, you know, that is completely unacceptable. And I think what we talk about with being fair is open learning processes, using a framework that's consistent no matter what member of staff you are. But actually it's not, it's the patient, the carer, the parent and the staff in the same space. So I think we have got progress, but we have also found that some organisations are much better at this than others. And I think also in particular examples where we have babies born in poor conditions get transferred to other units, sometimes those communications can break down too. So we need to improve, particularly best practice, and certainly when I've worked in units, is gone with people to visit mothers who are in other units, sat down with them to learn. So I do think there is some good practice. There's definitely a long way to go. But what we're trying to do is build resources to improve that, and also really building on the feedback that we get from people like Joe and Sue. But how can we do this better? Because actually the most powerful way of changing practice is to hear what it feels like to be on the receiving end of us. And certainly I think that's one that the Nadine Montgomery video is so powerful, because it's a real kind of compelling story about how things could have been different. And what we're asking for is not massive change, we're asking for a compassionate response.
Well, could I just quickly mention my experience, because I'm so old that I've spanned the time between really worst practice in litigation to much better practice, which I certainly identify now. But I remember the cliche, which was that patients, claimants, often said, if only someone had sat down with me and said sorry, if only someone had explained what on earth had gone wrong, I would never have gone to a lawyer. That doesn't apply to the women who are a desperately damaged child who need help with every aspect of daily care, but it applied to hundreds of people that I met over the years. And it's some kind of duty. It's a proper response to human suffering, of course, that we're asking for. And therefore, the duty of candour was important to bring in as an official line. But truly, what we really need is to educate people from medical school, nursing school, up in the ordinary behaviour of compassion towards those who've suffered. Anyway, I better move on, because And one of the other questions that was submitted in advance was this. Is there a case for piloting neutral chairs for serious complaints to ensure fairness? Not sure how you identify a neutral chair, or would it be best to require mediation compulsorily for the issue of proceedings? I wonder what Guy thinks as a lawyer about that, and then Jasmine, perhaps.
Well, thanks, James. Perhaps if I deal with the second arm of that question around sort of compulsory mediation. I mean, I think from all this talk about collaboration and the point I make really about making sure that we actually put our time, effort, and I dare say costs, our resources into those early phases of cases, so that we can produce better responses to all of this for everybody's benefit. I think there is a case for saying that actually there ought to be mandatory ADR of some sort. Now, I say that advisedly, because I don't think you can be too prescriptive about this, because feasibly it will be difficult to bring in mediation for every single case that walks through the NHSR's doors. But that's not to say that we don't say that there needs to be some form of better communication between claimant and defendant, whether that is by mediation, whether that's by actually maybe even a mediation by the NHSR team, or indeed those that are responding to the incident in the first place. I think there is a lot to be said for getting people around the table for a non-hierarchical discussion as early as possible. And so, yeah, I may be putting myself out on a limb there, but I do think that, I'm not entirely opposed to a mandatory introduction of some form of ADR, however that might be. I think what we do need to be careful about, though, is that we're not just doing it for the sake of it, because what we end up doing then is just adding an additional layer of cost, which of course we're mindful of at the moment. So it has to be with the best intentions, with good faith on behalf of everybody involved, with some clear purpose, and the better that we are of communicating what that purpose is, and going back to what I said about what we want to achieve, that actually we'll get much more out of that early phase.
Jasmine, do you have views on that question, but either about neutral chairs for complaints or compulsory mediation?
Yeah, I think probably, I'll wait. I'm not sure if they think, yeah, hi. So there was two questions. There was one about neutral chairs, for piloting neutral chairs to deal with serious complaints. So effectively having an independent person come in and help a trust when they're looking at a complaint. I think that does happen sometimes in the most serious cases, and where there's a recognised desire to have somebody eminent, experienced, perhaps a little bit further away from the staff that are involved than an internal colleague. So I think that does happen. It doesn't happen very often, and it probably adds sort of layers in terms of cost and timing. I think if we were going to enforce it as some sort of guidance or a best practice, then we would need to get some clarity about what those most serious cases are, so that the trusts feel comfortable about when that might be triggered. In terms of compulsory mediation, it sort of takes the fun out of it, doesn't it? Because Jo and Sue both said it needs to be voluntarily entered into, and you've got to have buy-in from the people that are going to participate in order to get the value from it. I think lawyers are a nightmare for needing a process and a rule to make things happen, and part of what Guy and I were talking about is the culture changing to engage brain and think about what in that case is going to get the right outcome, and that's what I felt really chimed from what Jo and Sue were talking about as well. So I wouldn't necessarily feel particularly excited about a new thing that gets imposed upon people, albeit I think the best practice and cultural aspects and underlying themes that we might want to encourage from behaviours is probably the right way to approach it for a start, at least.
Well, look, time is rushing on a bit, but in fairness to those who submitted the question, it's quite an important question, this one. which perhaps is more for the mothers who spoke to us about their own personal experiences. It's from somebody, I think, who has something to do with Petals Charity, which provides free counselling for parents after loss of their babies or children. And they're supporting, apparently, more and more people who are actually in the midst of the litigation process, which adds, as I was saying earlier, immense stresses particularly to bereaved people. The question is, would it be possible to make the availability of psychological support for parents on the litigation journey a statutory service, and so secure funding for the provision of the service for charities like Petals? I wonder if Joan would like to review on that.
Yeah, so actually with Harm Patients Alliance, jointly with AVMA, as was mentioned earlier, we're really keen to think about a harm patient pathway and what it is that we should be providing to people who have suffered healthcare harm, and to make it healthcare harm specific rather than the outcome of the incident specific. And so what I mean by that is we might have a bereavement care pathway, but it provides for the loss of a baby, not what happens if you've suffered healthcare harm. So if we have a healthcare harm care pathway that looks to understand and support the well-being and the needs of people to cope and recover after harm, then it would seem to me that for those patients and families that are going through a litigation process, having concern for their well-being throughout that process should be a part of that pathway, and that will certainly be something that we'll consider there. And who funds that would be up for debate, but it's probably something for the litigation companies, the lawyers' firms, to think about what they might contribute to that too, I'd say.
Thanks, Joan. So you spoke of the toll that it took on you in going through the litigation process. What's your view about publicly funded provision of psychological support during litigation?
Yeah, I think it's really important, and you know, we were lucky in the sense that so we were offered through our community team who were supporting Jasper. We were offered counselling support. This was just so after he was born, and when we were coping with his disabilities and the impact that was having on our lives. So we had support then, and then when we lost Jasper, the same counsellor obviously heard about his death because she worked at the hospital, and through the community team who had worked with him, and she got in touch again, and we had support again. And I cannot begin to tell you how important that was for me, how important it was for my husband. George and Freddie also received counselling after we lost Jasper as well, and it was an incredibly important part of the process. And I think that stands regardless of what happens at the end of a litigation process. You know, if people are dealing with children with severe disabilities, that is incredibly challenging, and having that support is really important. And then for people who are dealing with loss, it's incredibly important, and there is no kind of financial value that I could put on the help that we received through both of those periods in our life.
Could I just give a shout out there for the lawyers? I was always impressed by some of the solicitors who instructed me in these cases about how concerned they were for the psychological welfare of their clients, and some of them were extremely good at nurturing it and fostering a better sense of survival through the process. And I remember very early on, I was thanked by a lady who lost or had a very damaged child in childbirth by saying, look, I know this process of litigation is extremely worrying and anxious making, but listen, it's my job really for you, and I've got fairly broad shoulders. If you just imagine every day you're just putting it onto my back, and I can do it, it's my job, perhaps that'll help you a bit. And I remember the woman saying afterwards that she had tried frequently just to put the burden down and say, you know, I'm just a role player, but the lawyers will take the the load, the weight off my back. And I think we lawyers ought to remember that that's something worth saying and meaning to clients in this situation. I think those questions have all been extremely valuable and have promoted some very good discussion and answers. Thank you all. I wonder if Taz has got any others that she knows popped up, because I'm afraid our time is almost over now. What Taz has sent to me just now is this. Has the Swedish model, I'm going to read it off my phone, has the Swedish model to resolve claims suggested by Jeremy Hunt been costed?
The answer is it's massively cheaper. I mean, like, it's about 10% of the cost of our current system, because the result of that system, and I don't think it's just about litigation reform. There are other things they do as well, but the result, and actually there are some socio-demographic factors in Sweden. They have much less disparity between the richest and poorest in Sweden, and so they have a lower level of high-risk pregnancies in Sweden too. But taken together, because they have, you know, half the neonatal death rate and significantly fewer injuries, the cost to their system per head of population is around 10% of the cost of ours. It's massively less.
Could I just mention in that regard, I live in West London near the Swedish school, and I meet a lot of Swedes. Many of them have told me over the years they've escaped from Sweden because the taxation rate is 80 or 90% of the higher earnings. And of course, that means that in a population of about 6 million, they can afford social welfare for everybody at a very high level indeed. And they can fund healthcare in a way which ought to obviate the worst mistakes so far as is possible to do that. So one of the reasons it seems to me that Sweden is successful in this system is that they have this very high taxation and extremely effective and widespread social welfare system to deal and help people who need the sort of help which otherwise in this country is often only obtainable through damages.
I think that's, I will challenge you there, James. I mean, I think that, yes, they have well-funded social system, but they have half the neonatal death rate that we have. And that is a massive difference, and that is a cost on our system. I mean, we are spending £2.4 billion a year on compensation claims, and that money is money we're not. We spend more on compensation claims for maternity than the cost of every single obstetrician and maternity nurse in the NHS every year. And I would defy anyone to look at that and say that we've got the best system in that context. And I also would say that the role of the legal profession is incredibly important, because I've seen so many times, but not just in the case of Sue, who I know as a friend, but in many other times, that sometimes when a terrible tragedy happens, the only friend you have is the lawyer. The only person who's out there battling for you is your lawyer, and they do an incredible job at standing up for the small guy who is trying to deal with this massive bureaucracy. But whilst we recognise that, we also need to be open-minded to the fact that our legal system is not working at the moment in the way it's intended to, because the purpose of these big compensation awards that are made is to try and shake up large bureaucracies like the NHS to stop them making the same mistakes, but that isn't happening. We are carrying on making these terrible mistakes. And so I think we just need to be open-minded about the fact that other countries seem to have adopted approaches that are more successful in reducing these tragedies. And Sweden is one of them. But I think actually a very interesting one is Japan as well.
Well, thanks. Oh, Guy, you want to?
Yeah, I mean, I was just going to come in there, and I think. I mean, from my point of view, Jerry and I will disagree necessarily on the Swedish model, but and we perhaps haven't got enough time perhaps to explore that. I think it is really important to be open-minded about the way that we do things. I mean, the interesting thing about the Swedish model will be that I think it's important to see how that would translate to a UK model of healthcare, but also social care delivery, perhaps for another time. But what I would say is that I genuinely believe, and this is really, I think, coming across strongly today, is the fact that we can do so much more by working collaboratively and by pushing a lot of the work that we do to those early phases. And that goes just as much for the healthcare organisations who are doing the investigations, but the lawyers too. So if we can learn those lessons and help prevent the harm in the first place that's causing the cost, and then we can also make it a kinder and more efficient process that also not only looks after the patients and families, clinicians as well, but equally do it in such a way that it's more efficient. It'll actually reduce costs, and we've already seen that actually in recent reports from the NHSR. So I stand by the point I made earlier, is that fundamentally the system is one that's fit for purpose, but there is a lot more that we can do. I mean, we should be open-minded about that. I agree with Jeremy.
Well, thank you so much, everybody. We have, I think, I'm afraid, run out of time. I'd just like to, I think, to draw together the moral of what everyone has said today, very moving and very pertinently from those on both sides of the litigation process and from Jeremy. It seems to me that this is really, what is a patient? Is it just an interesting piece of broken machinery on which the healthcare professionals have the right and the license to practice their arcane skills? Or is it a person with hopes and fears, responsibilities, and so on, who requires you, and this also applies to litigants in the law, to be conscientious, careful, considerate, and above all, kind? And I think if we start with that proposition and the need for kindness and consideration, as well as conscientious and careful practice, we shall go a long way to making good some of the dreadful things that I've seen in the past, particularly, but which still to some extent persist. Thanks everybody so much for speaking today. I think it's been a really valuable and interesting occasion. And thanks everybody for joining us on this webinar. And also, if I may say so, thanks to Irwin Mitchell, who've done so much to promote this sort of event, and will be making the effort to produce more of them in the future. Finally, there is this feedback survey which is posted or will be posted, and I know how much it will mean to Owen Mitchell to have your feedback to improve and help them continue to produce really worthwhile it's like this. I also must say I personally look forward to one day us all being able to meet in person in actual rooms, which I always feel adds another important dimension. So thank you so much to everybody. And keep in touch and fill in the feedback forms. Thank you and goodbye.